right, somebody just came in on an iPhone. Who is that?
Alvin Little.
Little. And I don't have a Alvin Little on my docket today. Let's see what's going on.
You got a card.
All right, so you got it. In some way that you're signed in or something that's giving some feedback. Is that Alvin ALVIN Little?
Yes.
Just under 835? Yes, it is. All right. I got you, Mr. Little.
You have a Des McLovin.
Big pardon?
All right, who's on that iPhone? That iPhone is creating a lot of interference. So something that you're doing is creating some interference on that iPhone, Mr. Little.
Are you getting interference now?
Yeah, you're gonna have to call back. I got you checked in. You're gonna have to call back under some different way.
Is this my lawyer?
Say what now?
I'm trying to trust my lawyer.
All right, just call back because I can't even understand you. Your lawyer hasn't showed up yet.
No, he's called. Baby, how do you cut this off? Cut it off.
Put you out the room, sir. You're gonna have to
All right.
call back a different way. This is the city of Detroit versus Michael Marion Goodman, case number 217-215-701. Can you put your appearance on the record, counsel?
Good morning, Your Honor. Linda Perkins Moore, P 36136, appearing on behalf of the defendant.
All right. Just having a brief conversation with your client before he's got a situation where he's only charged with one count of driving while license, suspended, but he finds himself in a situation that driving while license suspended. I don't have Goodman's file, do I? Excuse me. Michael
Let me check.
Goodman, Marion Goodman. He finds himself in a situation that he's ineligible according to what he got from the Secretary of State. He's ineligible to get a license for another 2 years. I believe he said he checked on that at the beginning of this year. I told him that potentially the offer here is failure to display a valid driver's license. And I believe I understand what's going on without them just telling me this, is that he gets these tickets that abstract and he pleads to them or does whatever. This is why I can't preach enough that we need to start hiring lawyers before we get into these things. People say every day, oh, I'm gonna get the same thing, it's no big deal. Or like my father used to say, they buy what they want and beg for what they need, and they don't spend money. They don't want to spend money on a lawyer, but you find yourself in this situation now. Because here's the offer for your client that's written up by the city attorney is pleading to a failure to display. A failure to display doesn't give you any points, it's a misdemeanor, but it does abstract to the Secretary of State. So that could potentially, the Secretary of State knows you're driving again, and it could potentially give you another suspension like I said. Now, for your client, I can give your client a pre-trial date if he wants to. I can give your client a trial date if he wants to. But I can let you talk to him in a breakout room too, Ms. Perkins Moore. But,
That's fine.
We gotta start thinking about these things and making a relationship with the lawyer. So when you come to court, you got somebody representing you and you're not just trying to do it by yourself, because now you got a position where he's trying to change his ways and act right.
When he get ready to talk to you,
he can't get a
push that
driver's
button
license.
right there, that first button.
Listen, who's that
When he
on the phone? Gentleman in the glasses there.
Yes,
All right, what's your name, sir?
Alvin Little.
All right, I have you checked in. It's better now, Mr. Little. All right. All right, I'm gonna mute you until I call your name, all right? All right, join the room and speak with the lawyer. You got a very good lawyer. I suggest people take advantage of her knowledge that she's gonna bring to y'all today. Join the room. Let's see what Mr. Glover's got going on. Need an offer. You're not going to get an offer on this today. Let's see if we can get a state attorney in here to give you an offer.
Okay.
This is another ticket it's true. I'm not saying it's true, and I don't want you to say anything. It's absolutely unnecessary. Absolutely unnecessary. If it's true. You need to get a driver's license too.
Yeah, I was trying to, but they said that I don't know what was going on. I had already went to court for this case. I had already beat the case. I don't know how I ended up back in court for the case.
But you know how you end up back in, no, don't even get a state attorney. Hang up. No. You know how you end up back in here? Because you don't pay. Hang up, Ms. Nash. We don't need a state attorney. He has to pay. That's why he's back in here.
I never got no balance or nothing. When I went to the try to pay, I never had no balance.
Mr. Glover.
Yes.
How
Can you say it again?
old are you?
I'm 24.
24. You're a young man. That's not gonna, well, you were even younger at this time. Well, I'll give you a balance today. It's $266. All right, let's call the case. This is the city of Detroit versus Desmond Marquand Glover, case number SP 6503851. Let's also call case number SP 1189478. And we're going to call SP 1189411. This goes on and on.
Let me get those files to Judge, that we don't have to print them.
Which one out from?
No, because he's so close, so I gotta go find.
Oh,
them.
okay. All right, let's start over, Ms. Williams Law. This is the city of Detroit versus Desmond Marquand Glover, case number SP 1177541, counts 1, 2, and 3. SP 1189411, counts 1, 2, and 3. SP 1189478 and SP 6503851. All right. Well, we got the lawyer sitting in the room, but what I'll say to you, sir, is, first of all, the reason why you probably don't have a license is because you entered into this agreement back when you were probably just started to even drive. Have you ever had a driver's license?
Yes.
All right. And so I can understand why you just young and probably not really fully paying attention to what you were obligated to do at that time. So we're gonna try to get you back on solid ground here. Let me ask you this, sir, are you registered to vote?
Yes.
Okay, let's do this. Where's the lawyer? Go in the room. Let's do this. Let's give you an opportunity. Do you have any other tickets in any other jurisdiction, sir?
No.
All right, let's do this. Let's give him an opportunity to go get a driver's license. And the way I'm gonna do that is, I'm gonna waive the late fees and reinstatement fees on SP 6503851. I believe that you, just by being so young when you got these matters, you just, that's how these things fell by the wayside. And since that time, you've been operating without a license for this long. So by waiving that stuff, I got that in the printer.
Oh, yeah, open.
This will give you an opportunity to get clearances down here. I want you to come back with a driver's license.
Okay, appreciate it.
I'm gonna give you till April 4th.
Okay.
Well, April the 1st, 2022 at 8:30 a.m. We'll call it a pre-trial. And what I'm gonna do is I'm gonna waive now late and reinstatement fee on this matter. What that's gonna do is that's gonna get you back to the original agreement that you entered into. This was a 6-month delayed sentence. So you had an opportunity, sir, to get this off of your driving, to have this dismissed completely. I want you to pay this. Are you working?
Yes.
I want you to pay this ticket, SP 650385. Get a pen out. He was out there driving a brand new Mercedes and was flossing.
Let's see.
Well, isn't that what you were doing?
No, I wasn't flossing.
Yes, you were. At 18, at 16, what was it? What was that? 8 years ago now. That was
Yeah.
16 years old.
Uh-huh.
You had no business behind the wheel of that car in the first place, did you?
It was prom night.
See? Flossing, like I said. And he went to the prom early. He got a date. A senior came and asked Mr. Glumber. He was still wet behind the ears. What am I right, sir?
That was my senior year.
That was your senior year. All right. Listen, waive the reinstatement. Write this down, SP 6503851.
Okay.
I want that ticket paid when you come back. I
Okay.
want a driver's license. I'm getting you back to the original cost of the ticket. And then you better save up some more money because you got these other tickets sitting here. And at that time, we'll figure out what's gonna happen with those tickets. Ms. Perkins Moore, can you put your appearance on the record for Mr. Glover, please?
Linda Perkins Moore, P36136, appearing on behalf of the defendant. Defendant's name, please.
Desmond Glover.
I'm sorry.
Desmond Glover.
Okay, Mr. Glover.
So, Mr. Glover has, he's racking up a few tickets now. 1, 2, 3, 4, 5, 6, 7 tickets that are pending. I'm going to set aside the defaults in the SP 1189411 counts 2 and 3, so he can get an opportunity to be heard on those matters. I also see that what I see is that Mr. Glover's license is suspended, and it's suspended from an old matter. And I'm waiving the reinstatement fee and the late fee because he already pled to that in 2016. And I want to get him back to the original cost of the ticket, and I want him to get a driver's license. I gave him a pretrial date of April 1st, 2022. I told him that he has to have that ticket, that original ticket paid. I told him he needs to get a driver's license and bring it back in here. And then we're going to get him an offer on these other tickets. All right.
Okay. Yes.
Now, if you want to speak to him, I can put you in a breakout room if you need to. But if not, then he'll be back on April the 1st.
Mr. Glover, do you want to speak to me in a breakout room, or you want to just continue your plea and not guilty and get a pretrial date?
I could plead not guilty and get a pretrial date.
Okay.
All right. Do you understand what's expected of you, sir?
Yes.
All right. If it's nothing further, you have a very good day, sir. Good luck to you. I'll see you back on I will see you back on April 1st, all right?
Okay, thank
All right, have a great day.
you. You too.
Good morning, Your Honor. When you get a chance, can you put me in the breakout room with Alvin Little, please?
Good morning. All right, join that room, please, Mr. Little. All right, let's move up. Let's go back on the record with Mr. Goodwin. This is Perkins Moore. I'm giving you an opportunity to speak with Mr. Goodwin in the breakout room. Where is he? He's still on. Let's get him out of that room. All right, I can check some people in. Who was that? Our kids, iPhone.
Yes.
What's your name, man? What's your last name? Langley?
Good.
No, your last name is what?
Goodwin.
Goodwin.
Is that Nicole, Arikia?
Arkia.
Okay.
Okay, she's here. All right, let's call those cases. Arkia Nicole Goodwin. This is the city of Detroit versus Arkia Nicole Goodwin. Case number SP 7764481 and SP 7764491. Appearance for the record, please.
Linda Perkins Moore appearing on behalf of Ms. Goodwin, Your Honor. She's here for a review. Ms. Goodwin, state your name, please.
Arkia Goodwin.
All right, Ms. Goodwin, thank you for, are you working now?
Yes.
And you have kids?
Yes.
And she's the only one, I'll say, the only one that has met her obligations. Today is the date and time set for a review. I looked it up already. We're gonna close out SP 7764481. And we're gonna close them both. We'll close the blocking traffic out and we'll close the no ops out. I think that was under failure to display, I believe. Yeah, good for review. I got it. I got it. I should have got it. Let me get some. All right, so you satisfied that. We're going to close that one out. And then for the other one, we're going to close that one out under failure to display. And I don't think you have any more issues. Let me make sure. The other stuff is closed. You have a driver's license too, right now?
No.
Why don't you have a license?
Because I had to take care of my tickets and stuff. Well, with this case.
Well, you should get a license now. You would pay your reinstatement fees. I don't see you go to court or anything. Unless you have some other issues somewhere else. All right, if there's nothing further, thank you, ma'am. Good luck to you. Are you a registered voter, ma'am?
Yes.
All right, I encourage you, if you're not already in the process, I encourage you to get in the process, ma'am. We only had 18% of registered voters in the city of Detroit go out to vote. We're losing representation drastically, ma'am. You take that and do what you want with it, but I encourage you to get in the process, and I encourage you to encourage your family and friends and everybody else to do the same, all right?
Okay.
All right, there's nothing further. Have a great day.
So thank you.
All right, thank you. All right, now let's go back on the record with Mr. Michael Goodwin. Mr. Goodwin, I've given you an opportunity to speak with counsel in the breakout room. Counselor, what does your client want to do?
Linda Perkins Moore on his behalf, Your Honor. He's here for a show cause. He has not been arraigned. He would enter plea of not guilty, waives a formal reading, and stands mute.
Okay,
Wherein he would like to avail himself of the recommendation and tender a plea to a failure to display. Is that correct, Mr. Goodman?
Yes,
State your name.
Michael Goodwin.
Let me say this, do you understand that that could potentially implicate another restriction on their license where they can say that you're not eligible for some time later? You understand that?
Yes, Your Honor, it's my fault, so I'm gonna go ahead and,
It's not about
Take it.
being, it's not about being whose fault it is. It's about being smart about the situation. At this point, it's not about whose fault it is. This is what this whole system is about, sir. It's about them, instead of you just sitting there saying it's my fault, make them prove that it's your fault. But
yes,
I'm gonna accept the fact that you got good counsel, and I'm giving you an opportunity to speak with her. If you want to take the deal, you can take the deal.
yes, Your Honor. I just want to get it behind me, and I'm trying.
You know something, this is, I'm so sick of hearing that. I want to get it behind me. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Sir?
I couldn't hear you. That the camera went off. Yes, yes, Your Honor.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, you can put your hand down. We sit here in this world every day in the freest country in the entire world. Do you want me to tell you what makes this country so free other than other countries? Is
What
the
is it?
fact that you have the right to remain silent. That silence cannot be held or used against you. If you go to China or one of these other countries and they say that you committed a crime and they want you to give them some information that they believe that you did, they're going to say, if you say, I want to be quiet, they're going to say, hey, since you're quiet, you must have done something. Here, they can't say that. So when people sit here and say, I just want to get it over, I just want to do this. You said earlier that you want to get a driver's license because you're having trouble doing it. You have a system here where they have the right, they have the burden of proving you guilty beyond a reasonable doubt. Just getting it over is, hey, you can get it over, sir. Let's go with it.
No, it's just that I don't see your attorney told me that
No, I don't want to know what the attorney told you. That's private between you and her. What I'll do is I'll give him a pretrial date. He can go try to find something or somebody to help him with these other tickets. If you want a pretrial date, I'll give it to you. If you want a trial date, I'll give it to you. Or if you want to take the deal, I'll give it to you.
You said I have other tickets?
No, you just have this one ticket. I'm going to give you one last chance to speak with the lawyer in the breakout room. Rejoin the room. He seems very confused. I can't imagine that you didn't give him all the advice that you know out of all of your 30 probably years of experience dealing with this stuff. Go rejoin the room one more time, sir, and speak with her, and then come on back.
All right, Your Honor.
Good morning.
Morning, sir. How are you? This is a young lady outside. I know you're Zoom for it, but she is under the impression she's supposed to be here.
What's her name?
It was a complicated name. I think it's an African name. We got a couple of, I was the judge. Could it be ORIANW?
Yeah, let's come on in.
Okay. That could be one of them.
Larkin, David, William Larkin.
Here you go.
I can't hear you. What's your name?
Adesua Orion.
Odeshua Oriano?
It's right here.
Yes, I see. All right, we need to hold on. Now.
I'll send somebody in.
All right, thank you. All right, let's go with Mr. Larkin. This is the city of Detroit versus, oh, let me see what you have, Mr. Potts. Let me see what you have. Yes, OWBI. That's the offer. I have the file. I don't know if you have a copy of the allegations or not, but that's the offer.
I have the video, Your Honor.
That's
I
for me,
think I've
Mr. Walker, though.
seen the report before, but I don't have it.
I
don't know if you could send that.
Your device is something wrong with your device, Mr. There's something wrong with
Yeah,
your device, Mr.
I'm about to switch from my internet. My internet in my office is a little choppy this morning for some reason.
Good morning, Your Honor. Good morning. All right, let's call Mr. William David Larkin. This is the city of Detroit versus William David Larkin, case number 18-465-8001. Mr. Larkin, there's no offer in your file. What I can do is I can do one of a few things. Choice is going to be yours. I can get you an offer, which will likely be the same offer that was presented to Mr. Goodwin. That's failure to display, $240 fine. You're going to have to pay the reinstatement fee of $45. Can you put your appearance on the record, Counselor?
Linda Perkins, more on behalf of the defendant, Your Honor.
Okay. All right.
Hello.
I don't know why. Got how to bring that stuff up under his name.
Highlight the names.
Highlight the name right here.
Excuse me 1 second. I need everyone to remove their hats. Thank you.
That's what I know him. You don't know how bad.
It doesn't really matter.
Oh, yeah.
All right, here's the deal.
Right?
Hold on a second. Who's that talking?
Okay, my space is not-
Okay. All right, here's the deal for Mr. Larkin. First and foremost, he's got this, what's on the docket today. He's got a no ops ticket. I can allow Mr. Larkin to pay the reinstatement fee of $45 up front. And I can set him a trial date for April the 1st. I can allow Mr. Larkin to take the deal of failure to display, pay $240 plus the $45, and he can get that closed out. Or he can take the previous what I offered him in the beginning. But let me tell Mr. Larkin this. On February, on April the 26th, 2018, Mr. Larkin had a default judgment entered against him for failure to disclose to the officer that he or she is carrying a pistol. That fine for some reason, was all the way up to $500 and cost $106 and other things, which now they say he owes a total of $636. What I will do. How is this written tax garnishment file? How does that work?
Garnishment?
Yeah.
Your Honor, can I say something about that case?
No, not yet.
You said how was it filed?
How does that work if you waive the late fees and stuff like that? How does that affect that?
I'm not sure. You gotta go to civil for that.
We can still do the legal one. Argument, right?
Yeah, right.
Aye.
you can.
All right, so we'll waive the late.
You know,
Statement. Who is that talking?
I need everyone else to mute your devices other than the defendant.
All right, we can waive the late and reinstatement fee for that. Like I say, the offer is that. What I'm gonna do, Mr. Larkin, is put you in a breakout room. And you can speak with the lawyer on that. Before you go to that room, back to that room, Ms. Perkins Moore, you can tell me what's going on with Mr. Goodman.
Mr. Goodwin wishes to continue his plea of not guilty, Your Honor, is requesting a trial date.
All right, go join that room so you understand what his options are, basically the same as Mr. Larkin's options.
Correct.
All right, let's pass that matter. Let's go back on the record one more time with Mr. Michael Myron Goodwin. Mr. Goodwin, I've given you an opportunity to speak with the lawyer in the breakout room. Is my understanding that you want to set a trial date?
Yes, Your Honor.
April 1st, 2022 at 9 a.m. What I suggest, and then this is just, I suggest you go see what you can get some relief on that other thing. You'll set a trial date. You can't do any worse than you do today. You may do better. You may do better, but you can't do any worse. So at the very least, you'll save yourself some time to pay that $240 fee. But you may not have to pay it because the officer may not show up, or the officer might not recollect, or the officer might not be able to find you guilty beyond a reasonable doubt. I don't know. So take that for what it's worth, sir, and go ahead and try to get some information on how to get a driver's license. I'll see you back April 1st.
I have a question.
All
Do
right.
I go to the same Zoom number or
Same Zoom number. Everything's the same
at April 1st at 9 o'clock?
at 9 o'clock.
Okay, I appreciate it, Your Honor.
Have a great day.
You too.
Your Honor, you want me
Your Honor, this is William Martin.
Mr. Larkin?
Okay. I joined the break room, but I had joined it too early.
I'm trying to get a city attorney in here. Yeah, you go in the breakout room with Mr. Larkin.
Okay.
All right, let's see who's next.
You want me to join too?
Yes, he's in.
Okay.
Yeah, he's in two. Mr. Larkin, you join breakout room 2 as well. All right, let's Mr. Lawson, he doesn't need a lawyer. Well, he might. But
Your Honor, I spoke to Mr. Little. He wants to take advantage of the plea, but I'll probably need the report in order to walk him through a factual basis.
all right. Mr. Little, can you do that report of Mr. Potts?
Okay, yeah.
We're sitting on top. All right. Mr. Timothy Darnell Lawson.
Yes, sir.
This is the city of Detroit versus Timothy Darnell Lawson, case number SP 11004921, SP 11326733, SP 11497413, and U 50323919. Sir, apparently, I wrote down here, you seem to have paid off one, that's U 50323919. I will, I'll dismiss that case. As it relates to see what's going on the line, that's the 11004921.
Your Honor, you said as it relates to, and then you called a particular case, but I heard rustling in the background that kind of muffled what you said.
SP 11004921. You also paid that, sir.
Yeah.
I'm gonna dismiss this.
I paid 23,919 too. And I partially paid on
Let me see. You have SP 11326733 that you made a partial payment on.
yeah.
And I will. All right, how much time do you need? I'm gonna give you some more time, because obviously you're taking care of, you're making very good effort to do this, so how much more time do you need?
Need like a couple months if I have it.
All right, I'm gonna give you till pay by April 16th, 2022. Have a review. Same thing, 8:25 a.m. I'm gonna have you back then. And then we'll include that other case number of SP 11497413. All right, you still owe 240 on that. So I'll also include that case. April 16, 2022. Review 8.5. Can I make a suggestion to you, sir?
And what's that, sir?
I would suggest, you owe an awful lot of late fees. He owes 17,310,081. He owes, money on that too. Let's put that April 16th. I would suggest that you pay these $45 reinstatement fees first. That way you would be clear to get a driver's license.
Sir, I already got my driver's license back.
Dude,
Yeah, they gave me my driver's license, and this stuff here, I don't know. They gave me my driver's license, and then
yeah, he has a.
after I went to court, they actually suspended it after I went to court, and they made me pay another $125. And those $45 fees, they said when I went to the court, when I came down to the 36th District Court, they was like, they gave me a list of the stuff I needed to pay, and they said I didn't have to pay that $45 fee. Said it was sent to the Secretary of State, and that I didn't have to pay it.
Okay. We'll leave it at that then. I mean, you do have a valid license. I think I was mystified by that when you came in the first time.
Yeah.
Yeah, I do have a valid driver's license. All right, I'm gonna give you till April you owe $174 on the 17,310,081 ticket as well. The birthday is 6/16/1981.
Correct.
What's your name, sir?
Timothy
Lawson.
Lawson. And he's here for a review. I'm giving him till April 16th. He's made substantial headway in the payment. Are you a registered voter, sir?
Yes, sir.
All right, I encourage you, if you're not already, to get in the game, sir. We're losing representation. Only 18% of registered voters in the city of Detroit actually voted. We're losing representation at astronomical rates, all right?
Yeah, I understand.
All right, if there's nothing further, I'll see you back on the 16th.
Yes.
All right, let's get Mr. Larkin, and then we'll go to the lawyer. Let's go back on the record with Mr. William David Larkin. And Counselor, I have presented to you in your client what I see here in Mr. Larkin's file. I gave you an opportunity to speak with him regarding the matters. What your client want to do?
Your Honor, he wishes to continue his plea of not guilty and pay the reinstatement fee. He has a very poor connection.
Okay, I'm gonna say pay reinstatement fee up front. I don't see on this register of action that there's the man. Good morning to you.
Good morning, Your Honor.
I don't see on this register of action on the ticket that he owes that this is, let me, you can probably, you can't answer that, Mr.
What's the case?
This is just a case of him having an old ticket of not disclosing his pistol license. Does that suspend your license?
I'm not sure how Secretary of State evaluates this.
Okay.
And this is a state count. Okay, so we got to call judge and civil action.
Yeah, I don't know.
Non-traffic.
$500 fine. That's awesome. We'll figure that out when you come back. Pay the reinstatement fee up front, Mr. Larkin. The best thing I can tell you to do is to come down to the courthouse and pay that as soon as you possibly can. It's gonna be a $45 fee. And if you pay that $45 fee, you can potentially go get a driver's license. I'm gonna set a trial date for this matter, April 1st, 2022. And we'll deal with this other state ticket. If there's I waived the late and reinstatement fee on that. We'll deal with this matter on April 1st, all right? You have any questions, sir? This is bad connection there.
Excuse me, Your Honor, are there some cases that you want me to address?
Yes.
Okay, good.
All right, let's do some inventory right now. I have Corporal Ambrose in the room. I have Corporal Hope in the room. Good morning to you. I have Officer Hill in the room. I have Officer Corporal Rule in the room. Good morning to both of you.
AJ went to the concert the other night.
Are we done?
Okay.
I need you to mute, Mr. Little. Mute your device, sir.
Your Honor, this is Mr. Larkin. Would I be able to
Morning,
have
Your
a
Honor.
ticket this week?
Hold on. Let's get Mr. Larkin. Say that again, sir.
I said, would I be able to handle this ticket this week if I?
I can't understand you.
Can you hear me now?
Yes.
I was wondering, would I be able to handle that ticket this week if possible?
What ticket? You'll be able to
The,
pay that reinstatement
the
fee.
I'm sorry, Your Honor. I was saying, yeah, the $45. Will I be able to pay it this
Yeah,
week?
pay that today. Pay that. You can come down here and pay that today. And if you don't have any other tickets in any other jurisdictions, that should potentially allow you to go to Secretary of State and ask them for a license. And then come back on April 1st, 2022, and we'll deal with those matters, all right?
Okay.
All right. If you have any questions, call the court. All right.
Okay.
Officer
Thank you,
Gaynor.
Your Honor.
All right, thank you. Officer Gaynor, good morning. Officer Shabazz, good morning. I don't see Officer Gaynor. Who do you have, Officer Gaynor?
Morning, Your Honor. I have Colby Lyford.
Okay, he's in here. I don't see, who is QUAS? Oh, that's his lawyer. Okay, very well. Everybody's here. All right, let's get this going for the trials. I have Vanessa Gidding. I don't think that she's Officer Vickers. She's here. I have Langley is here, and I have at least two officers for Langley.
You're taking Vickers back, Your Honor.
Yeah, I'm taking Gidding.
Yeah, that's
Gidding's back.
Officer Vickers is on that.
Yeah,
So what are you gonna do with it?
if he's not here by 9:30, I'm gonna dismiss him. And then we have,
I'm sorry, did you call me?
who's that?
Gibbon? Oh, D'Angelo?
You said Gidding's D'Angelo?
No, he thought
Yeah.
he was.
Let me see if he's on here.
Yes, he's on the 9 o'clock trial.
9 o'clock trial.
Yeah,
D'Angelo.
I was waiting on my attorney. I've been here since 8:30. Well, 8.
All right, that's fine. Here you go for him, D'Angelo Giddings. Okay. Who else did we have? Is Tamika Giltz here? No. Is Janice Leonard here? Is that you on that iPhone? You have to unmute yourself, man. Is that you on that iPhone? Is that Janice Little? I mean, Janice, Leonard? I don't know. I can't hear her. I'm assuming that's Janice Leonard.
She's shaking her head, yes, Your Honor.
Okay.
Can't get her audio.
You gotta unmute yourself, Miss Leonard.
So, Your Honor, for all the files, I'm gonna have to, I guess, talk to the officer.
Yeah, I'm gonna put you in a breakout room when you sign on. I'm gonna put you in a breakout room and put everybody in the room with you. I don't know if Nicole Osley is here. I know that name, and Tamika Giltz, I know that name, but I don't see either of them in the room yet, but I'm gonna give you all those cards.
Okay, can I? Okay.
All right, I'm gonna put them in a breakout room. Officers, you can join that room and the city attorney's gonna be in there in a minute. He's dealing with a couple other courtrooms. All right, let's move on. All right, let's see. I guess we're not gonna get Officer Vickers, so Miss Giddens, you're next.
Yes.
This is the city of Detroit versus Vanessa Giddens, case number SP 1196999, counts 1, 2, and 3. SP 1197022, counts 1 and counts 2. Appearance for the record, please.
Linda Perkins Moore appearing on behalf of Ms. Giddings. Ms. Giddings, state your name.
Vanessa Giddens.
My understanding, Your Honor, these matters are scheduled for trial. The officers failed to appear. We would make a motion to dismiss.
Okay. Officer Vickers, hearing no response, and today is the date and time set for a trial. That being said, council has a motion to dismiss the trial date. Trial was supposed to start at 9. I give the officer a half-hour grace period. Officer Peacock just made it in. I'm gonna dismiss the case. The case is dismissed, no officer. All right? You have any questions, ma'am?
No, I do not.
If there's nothing further, have a great day, ma'am.
Same to you. Thank you.
Okay. Bye-bye. All right. Let's move on to I have an in-person here, counselor. The issue with the in-person doesn't give me really an opportunity unless we get the city attorney to allow them to use their device to speak with, have a private conversation. But we'll see where this goes. Give me. Adesua. And what is the last? I want to get it right. Adesua. All right. And Orianwo. Adesua Orianwo. All right. This is the city of Detroit. Come on up now. This is the city of Detroit versus Adesua Orianwo, case number U6004611. Appearance for the record, please.
Linda Perkins Moore, appearing on behalf of the defendant, Your Honor.
State your name for the record, ma'am. Okay. Now, this is a disorderly conduct case. Let's get this ticket to. I'm gonna give you the ticket so you can read the allegation that's on there. Your client.
I believe I know what the ticket says.
I'm not talking to you.
Oh,
I'm sure you probably do.
I believe you.
I don't know. Because you're coming here with a defense saying it wasn't me, you know, and that's perfectly all right, whatever defense you want to go with. But I'm getting that to your lawyer, so your lawyer can see. Ms. Oriano, it indicates that she is a medical worker. Where do you work, ma'am?
Children's Hospital.
At Children's Hospital. I'm going to let you look and read over the ticket. There is an offer in the file to plead to a 6-month delayed sentence. I would dismiss the ticket immediately upon payment of the $240, but I don't know if you want your client, based on her representation that she is an employee at Children's Hospital, to be making that sort of factual basis. But I'll allow you the opportunity to review it, and I will allow you somehow to confer with your client, and you guys, so you can help her make an informed decision on what she wants to do. That offer also will remain open if there's a need for a trial, and I'll let you review that. All right, Ms. Perkins Moore.
Yes, Your Honor.
Okay.
Yeah, it's my understanding she's saying it's not her.
No, I didn't say that.
Okay.
She was gonna speak on the matter, and I told her I don't want her to say anything, because you may raise the defense that it's not her. I don't know. But I didn't want her to, if she was about to implicate herself, then I didn't want her to do that on the record without you having an opportunity to counsel her.
Okay. Did you hear me? Did you hear, ma'am?
Yeah.
Okay. My name is Linda Perkins Moore. I'm your attorney today. Now, the judge says giving you an opportunity. A delayed sentence is a sentence meaning that you would plead guilty, but once you pay all the fines and costs, instead of it being a 6-month delayed sentence, it would be dismissed from your record immediately, which means it wouldn't be on your record at all. So if you decided you want to plead guilty, you can go ahead and do that. And as soon as you pay the ticket, it'll be off your record, so it wouldn't affect your employment at all with the hospital. You do also have the right to continue your plea and not guilty and schedule a trial date. Do you want to take this offer today and plead?
Yes.
Well,
okay.
I just, the only hesitation is I don't, and it's just me. You're representing her, and I don't like making a factual basis if she didn't have to those things based on her employment.
Your Honor, can we do a contest?
Well, we can set a trial date. Let's set a trial, and let's do that. Let's have her back.
Okay. That's fine, Your Honor.
At that date, we'll figure out something will happen.
Okay,
Now, why is it that you came down today, ma'am?
Well, because I had this scheduled, I had another charge that was linked to this one that could not get settled the last time I came. I don't know if I came before you or someone else. The last time I came, this could not be resolved until my past charge was. So I'm already, I didn't want to say too much, but I'm already dealing with an additional charge that was had to do with this incident already. So
Okay, okay.
I'm on a 6 months probation.
Okay, so what we're gonna do, we're not gonna compound things out of the same set of circumstances. It was a more serious charge, and I believe that there was been some resolution to that that would put you on that has some court oversight, I'll just say that, correct?
Yeah.
All right, so what we're gonna do is we're gonna dismiss this matter.
perfect.
I
No
hope-
objection.
I hope that that this kind of, I don't know what happened out there. But I hope you seriously learned something from this.
Yeah.
That's what's most important. But so we're not gonna even go over there. All right. All right, if there's nothing further, case is gonna be dismissed based on the abstraction that was entered into on at the circuit court for the same set of circumstances. All right, that's it. I'll take that ticket back.
Oh, yeah, I'm sorry. Is it okay?
All right, there's nothing further, ma'am. Have a very good day. Good luck to you.
You too.
All right. All right, let's move on. Thank you.
Not a problem.
Anytime.
Anytime.
Come on in.
Thank you.
Some of this.
You can ask the doctor.
No. Okay, Mr. Well, what do you want to do, Mr. Potts?
Judge, I'm on the record in Giles right now. Mr. Little is
All right,
going to
go
plead,
ahead.
but I'm finishing up a motion.
Go ahead. I got Ronell Gatlin.
Yes, Your Honor.
Good morning. How are
Good
you?
morning. I'm good. How are you?
I'm good.
Oh,
Okay. See what Mr. Gatlin has going on.
Oh, God, please. Yeah, no,
I have your statement, and that's mine. You want your?
Oh.
It doesn't matter to me. I had it for a while. All right, let's call the case. This is the city of Detroit versus Ronell Cortez Gatlin, case number 214-15830, counts 1, 2, and 3. We'll also call case number 16-27829, counts 2, and counts 3, and 16-2899-761. Appearance for the record, please.
Linda Perkins Moore, appearing on behalf of Mr. Gatlin. Mr. Gatlin, state your name.
Nail Cortez Gatlin.
Mr. Gatlin is here on show cause matter. Your Honor, if he has not been arraigned, he wishes to enter a plea of not guilty, remain, stands mute and waives a formal reading.
All right, and there is an offer in the file. First of all, what I'm gonna do for Mr. Gatlin, do you have a driver's license, sir, or not?
No, sir.
What I'm gonna do for him is I'm gonna waive these 2016 tickets. I'm gonna waive the late and the reinstatement fees. I'm gonna get them back to the original cost of the tickets. That could potentially allow him to go get a driver's license. I will give him that opportunity if he wants to, see if the city attorney is willing to give him a little bit better offer than it is today. Today, the offer is pleading to the failure to display. That's gonna be a $240 fine. It is a misdemeanor that will abstract to the Secretary of State. However, it will not, does not have any points attached to it. And then the other 2 counts will be dismissed. So you can either take that today, you have an absolute right to a trial, or you can try to go get a driver's license, like I said, a pre-trial, and you see if yourself or the attorney on that day will be willing to offer you something, anything different than that. I'll allow you to speak with Mrs. Perkins Moore in the breakout room if you need to. You let me know what you want to do, sir.
I would like to speak to attorney, Ms. Perkins.
Very well, very well.
Thank you. Thank you, Your Honor.
All right, I'm gonna put you in the room, sir. Talk to Ms. Perkins Moore and all right. The rest of the people here.
Room 2.
Yeah, you're in room 2 all the time, unless the rest of the people, Terrence Grant, I haven't seen him. All right, he'll be next. The rest of the people are here waiting on trials. Little has got his lawyer waiting on him. Lifer is waiting on the trial. Who's the gentleman on that phone? Gibbons? Who's on that phone? 702-720-9312.
Oh, that's not me.
Who's on that phone? 702-720-9312.
Eris Langley.
Say that again.
Eris Langley.
Oh, Eris. Okay, you're waiting on a trial, so let's put a. And then I believe that I never got confirmation. Let's see, where's Gibbons' spot?
Have you?
I thought I had all the trials. It wasn't due
Oh, let me check it on.
Yeah, D'Angelo. I'll give you your schedule. Boston. We took care of Boston already. Okay, Councilor Morgan, I'm gonna put you in a breakout room.
Good morning, Your Honor. This is the prosecutor.
Did that work? Did you join that room? Face, who is Face?
Robert Gribble.
All right, Robert. Gribble.
In the second half, that defensive line, Raheem Morris called it great gameplay. He said, guys, we have got to win.
Ripple, I don't see.
He's here on, I think he's 8:35. Let me see, hold on. I checked him off. Okay. Yeah, he's under 10 o'clock here, on a pre-trial 10 o'clock. I'm not sure why it's 10, but.
Oh, right on there. All right.
I just looked at that, it's like some handouts, like a motion or something. And I don't have, I don't have.
Motion. This is for, where's your lawyer, Sinclair?
Yeah, he should be in here. That's what I was looking for.
No, he's not due till 10, so he's got a few more minutes. But I didn't get any of this stuff.
Yeah, because the original court date was actually for like January 28th or the 29th, and they rescheduled it. Yeah, they had rescheduled it to today.
All right, well, I never got a motion from, he filed a motion. Who's this? Who's this? Is it a state case or city case? All right, we'll set that aside. Where is all right. Where is D'Angelo Gibb?
Yeah. Can you hear me?
Who's that?
Angelo?
Yeah, hold on a second. I'm talking about, I'm just speaking out loud. Let's see if he has it.
Oh, okay. Yeah, I've been here since 8. So
Everybody has.
yeah, I'm like, I don't know where everybody else is right now.
Let's call his case. City of Detroit versus D'Angelo Emmanuel Gibbons, case number U59884321. Appearance for the record, please. And we don't have a house counsel here. Put your name on the record, sir.
D'Angelo Emmanuel Gibbons.
Do you have a lawyer?
Yeah, I don't know where she is. She should have been here a while.
Call this lawyer up and tell her to come in here. We're gonna pass the matter until the lawyer comes in.
Oh, okay.
You said Gribble? or who was it?
Gibbons, here's a ROA.
Oh, okay, got it.
Here you go.
That trial.
Yeah, here's
Oh,
an
okay.
ROA right here.
Oh, I had it.
You got a lawyer, call that lawyer up.
Your Honor, I'm back and ready on a little whenever the court's ready.
Yes. All right. Let's get, you see that lawyer's here. All right. Let's call the case. Let's pass Mr. Gibbons' matter. Let's call the case. This is the city of Detroit versus Alvin Little, case number Z8081491. Appearance for the record, please.
For the record, Your Honor, Coleman Potts, P78607, on behalf of Mr. Little, who appears by Zoom. Mr. Little, please state your name for the record, sir.
Alvin Little.
Your Honor, today date time set for a pretrial in this matter. I have one over the plea recommendation with Mr. Little. He wishes to take advantage of that plea recommendation and enter a guilty plea.
Is that the case, sir?
Yes. Yes.
All right. Can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down, sir. Sir, you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
And for 360 hours of community service, driver's license suspension for 30 days, followed by license restriction for 150 days, 6 points added to your driving record, and driver responsibility fee. You understand that, sir?
Yes.
Well, Your Honor, I went over the rights or the consequences of the OWVI, since that was the plea recommendation.
I'm going over a mass charge that's written in the information or
Okay.
the complaint. The OWVI would be a 4-point offense. It would be reduced to, it's still punishable by 93 days in jail and or $500 in fines. It'll reduce to 4 points. It'll reduce to a 30-day suspension, but that 30-day suspension will automatically, by operation of a law, go to a 30-day restricted driver's license. You understand that, sir?
Yes.
You understand that you have a right to a trial?
Yes, Your Honor.
You understand by taking this offer, you'll give up that trial right?
Yes, Your Honor.
Has anybody offered you anything other than what's been stated in the record?
No.
They're trying to work on getting someone right now.
All right, counsel, you want to voir dire your client?
Sure, Your Honor, I'll bring up the report. Give me 1 second. Mr. Little, turning your attention to events that happened on or about January 21st, 2021. Were you operating a vehicle in the city of Detroit?
Yes.
And that you were operating that vehicle near Gratiot Avenue and Connor Street?
Yes.
Okay. And while you were operating that vehicle, did you get into a car accident?
Yes.
Okay. And before you operated that vehicle, did you consume intoxicating liquors?
Yes.
And for the purposes of the factual basis, will you stipulate that your blood alcohol results were 0.15?
Yes.
I'm satisfied, Your Honor.
All right, I'm satisfied. I guess the people are not here. So we get a sentencing date. We're gonna have your client report to probation. We're gonna get PSI drawn up on your client. And then what date for sentencing, this match after PSI and stuff? You say 60 days?
I would say 60, yeah.
All right, we're gonna say April 16th for the sentencing date.
I think that's the wrong date, you know.
It is. We already gave it out
I
once.
know, I think it's the 18th. 16th Saturday, so the 18th.
April 18th is the date.
That was April 18th, Judge.
Yeah, April 18th for sentencing. We gotta go through some conditions here. I don't believe I put any conditions on your client at the previous pretrial date, or did I?
I don't recall, Your Honor. I believe I was appointed after the fact.
No.
All right, so your client is going to have to submit to some random drug urinalysis, alcohol testing. So we're gonna have him submit to some random alcohol testing. One time bi-weekly. So I think result in him having to approximately 4 times having to do that. We're gonna no alcohol during the pendency of this case, sir. Not leave the state of Michigan without the permission from the court. And that probably will be the sum and substance of the conditions I'll impose on him. We'll have him back for sentencing on April 18, 2022 at, let's have him back at 10 a.m. for sentencing. All right, I'm gonna order you to go to probation. I'm gonna give your client that probation number, counselor, that 313-965-3414 number. So he can get set with that alcohol testing. And if they don't contact you, sir, by, I would say, Thursday, you need to get in touch with either your lawyer so he can get in touch with them, or contact them yourself. I'll have you back on April 16th, 2020. 18th. Sorry, correct that. April 18th, 2022 at 9 a.m. At 10 a.m. All right?
Yes.
All right, any further questions?
No, Your Honor.
All right, very
Not on
well.
behalf of the defense, Your Honor.
Have a very good day. Good luck to you, Mr. Little. I'll see you later, Mr. Ponce.
Thank you, Judge. See you this afternoon.
All right, thank you. All right, let's go back on the record with Mr. Ronell Cortez Gatling.
Yes, Your Honor.
I've given you an opportunity, sir, to speak with defense counsel in the breakout room. What does your client want to do, Ms. Perkins Moore?
Your Honor, we need a clarification. He wants to pay the reinstatement fee to get his license. However, according to Mr. Gatlin, and I'm not sure if the court is aware of it, he is on a payment plan with other outstanding matters at 36th District Court, and he wants to clarification as to whether when he pays his $45 reinstatement fee, is that going to get his license back, or does he have to comply with all the other matters that he's failed to pay in the payment plan?
Well, he's on a payment plan, but that was way back in 2017. I don't know if that's still good or not. He doesn't owe any reinstatement fees for these cases right now. I don't know, other than the civil infractions that he entered into the payment plan back then. I don't know would be holding his license up unless he's got some other things going on in other jurisdictions. But I'm just gonna look. I see that he has a payment plan for those, one of them is closed for 3 tickets. It says the last payment of $22.
Oh.
Who's that? Due on 4/22. I don't know if this payment plan is still any good.
I don't think it is, Your Honor. I was just saying that I was on the payment plan back then, and I owed it like about $800 or less than under 800. But I just want to know: are you dismissing all my tickets for 2016, or just for this matter?
I'm not dismissing anything right now.
Okay. Okay.
I'm not dismissing anything. I'm giving you an opportunity. I told I would waive the late fee or reinstatement fee for those old matters, and I'm gonna give you an opportunity to clear those matters up. After that, there was a reinstatement fee would have been on those three matters that were back in 2016. With that waiver, those late fee and reinstatement fee, that should clear up the case. If you have a second, you don't have to finish that. But you know, look this up and see what what's going on with one of those tickets when you get a chance. You can finish that up. Let's do this. Let's set a pretrial date. April 1st, 2022 at 8:30 a.m. In the meantime, when Ms. Nash is done with looking up the stuff, doing what she's doing for Mr. Little, I'm gonna have her look up and see what's going on with that one case, or at least one of those cases, to see if there's any reinstatement fees due on that. Or is there any reinstatement fees on that?
So this one, okay, let me check. Right, his license is it's been 16.
Can we waive that reinstatement fee and the late fee?
Yes,
All right, so we're gonna waive the reinstatement fee and the late fee. You should be able to get a driver's license after you waive off 48 to 72 hours. That's if you don't have anything else in any other jurisdictions.
No, I don't, Your Honor.
You're gonna have to pay these. I want these to be paid by April 1st. And then you come in here and we'll deal with the other tickets on April 1st, all right?
Okay, thank you.
Pre-trial 8 a.m. So go get a license, sir.
Okay, Your Honor, thank you.
All right, there's 3 of those tickets in there.
Yeah, those okay.
All right, I'll put the writing on.
And he's not in that payment plan anymore because they gave him final notice.
Now, pay by April 1st. Yeah, pay by April 1st. All right, anything further, sir?
No, sir. Thank you.
All right, so go to the Secretary of State in 48 to 72 hours and see if you can get a driver's license pre-trial for the other matters, April 1st, 2022 at 8:30. And we also have a pay by date. That's gonna be those old civil infractions. You're gonna have to pay those by April 1st as well. So when you come in here, I want those matters to be paid.
Okay, Your Honor. Do you see those matters? Like, can you tell me how much are they?
One of them is now $102 from 200 and something. You're gonna look up on the thing yourself to get that. One of them is right now $336. But it's gonna be probably substantially less than that. I have 195, so 102 and 195, and then I don't know what the other matter is, but anyway, we've gotten the reinstatement fees off of you, and you gotta pay them. All right, but that shouldn't be preventing you from going to Secretary of State now and getting a license. All right.
Okay, thank you.
All right. Is anything further, sir? Are you a registered voter, sir?
No, Your Honor.
All right, come back in here with that you registered to vote, sir.
Okay.
You gotta get in the game, sir. We're losing representation at astronomical rates. You gotta get in the game.
We're gonna lose more than that if people don't vote.
We're gonna lose more than that.
Yeah.
I'm going to vote, sir. I'm gonna do
Well,
it.
you gotta register first. I want proof of registration on April 1st too, all right?
Okay,
It's
you
easy.
got it.
All you gotta do is go online. You can do it right now in a matter of about 15 seconds once you get online.
Yeah.
Go to
Okay.
Secretary of State, just punch in SOS, voter, register to vote, and it'll put you right there, all right?
Okay. Thank you.
All right, have proof of that when you come back.
All right. Thank you, Your Honor. Have a good day.
All right, have a great day, sir. You're welcome.
You too. Thank you. Bye-bye.
All right. Mr. Sinclair. Good morning, Mr. Clipper.
Good morning,
Yes.
Your Honor. How are you?
Very well. What's your client's name?
I'm standing in for Ms. Fryinlick for Mr. Gibbons.
Yeah, where is she?
Unfortunately, Your Honor, she's in urgent care this morning.
That's very good, sir. This is the city of Detroit. We're recalling the case of D'Angelo Gibbons, case number U59884321. Can you put your appearance on the record, counselor?
Good morning, Your Honor. Need a Clipper P77992 on behalf of D'Angelo Gibbons, who appears via Zoom. Mr. Gibbons, do I have your permission to stand in for Ms. Fryinlick this morning?
Yes.
Thank you. Your Honor, well, we consent to this hearing via Zoom. We are here today to enter a plea. The city has.
Not yet. No, not too fast. I don't know if you're gonna do that right now. If you want to, I can let you, but today is the date and time set for a trial in the matter. I called Officer Sherry Tanner, and I got no response. Trial set at 9 a.m. and I give officer a half-hour grace period to get to the court. Be that as it may, there's no response, and I never saw Officer Tanner in here by 9 o'clock, and I still don't see Officer Tanner here. So you want to make a motion?
Yes, Your Honor. At this time, Your Honor, we ask to dismiss this matter. Motion to dismiss this matter.
Who's talking?
I don't know.
Someone's
Is that
talking.
Mr. Gibbons talking with the
No.
neck roll?
That's not me.
Okay. Well, who's got that neck roll on their neck? You think it's funny, sir?
I'm not even talking to you. I'm talking to my background.
I know, so cut your background off, take the neck roll off of your neck.
All right.
All right, so go ahead, counselor.
Your Honor, we respectfully ask to dismiss this matter.
All right, I'm gonna dismiss the case, no officer. All right, anything further?
No, Your Honor.
All right, very good to see you, counselor. And Mr. Gibbons, good luck to you as well. Are you a registered voter, sir?
Yes.
All right, I hope you're in the game, sir. It's nothing further. You all have a very good day.
All right.
Thank you, Your Honor.
Thank
Have
you.
a great day and everyone continue to stay safe.
All right, you too.
Thank
All right,
you.
Mr. Sinclair,
Yes, sir. How are you, Judge?
very well. What's going on with this case? Did you ever work anything out?
So I sent follow-up information to see what the final position of the prosecutor's office is or was, and I didn't get a response. So I was hoping for either a breakout room today to get that information or just move forward with arguing the motion.
All right, let me allow the regular city attorney is not here. I got Mr. Morgan from the city law department. He's in the breakout room and he's dealing with a lot of officers right now. So as soon as he breaks away, he's free. Then we will give you an opportunity to speak with them. Okay.
All right. Thank you so much.
All right. Counselor, do you have a resolution for your client, counselor, for Mr. Lyford?
Good morning, Your Honor. Jeff Buzz, here on behalf of Mr. Lyford. Your Honor, I was fortunate enough, and I certainly appreciate the city attorney getting me discovery with regard to Mr. Lyford. I actually reviewed the video. I think as a result of it, we should get a resolution. I can't tell you whether that will happen today. I don't know whether the person I'm going to deal with today has actually watched the video, but I think it provides a great deal of information that would lead to resolution. So
Today is the date and time set. Today is the date and time set for a trial. Let's call the case and we'll have, we have, this is the city of Detroit versus Colby Lyford, case number SP 1192807, counts 1, 2, and 3. Appearance for the record, please.
Jeff Quaz on behalf of Mr. Lyford.
Mr. Morgan, can you put your appearance on the record, please?
Yes, Stephen Morgan on behalf of the city of Detroit. And by the way, Your Honor, I just updated an offer. And I'm not sure if you'd like to hear that offer right now.
Sure.
Well, I hear the offer, but I think what Mr. Quas is saying is that, well, go ahead, put the offer on the record. Go ahead.
Well, right now, the offer is to plead to count 1 of SP 1192807, that's drag racing, and to dismiss counts 2 and 3. I have my officer here, and also, just for continuity's sake, this is the offer that was left by my colleague. And I'm just updating it today after having spoken to the officer. Okay.
And is that the same offer that, is there an actual update to that offer, or is that the same offer your colleague gave at the time?
Same offer. That's the same offer that my colleague gave at the time. I mean, it expired on the day that it was given back in November 10th, but based on the terms of the offer, but I am renewing it today, the same offer.
All right, now go ahead, counsel. I'll let you speak to put on the record.
Your Honor, based upon that, we would not accept that offer. What I indicate to the court, based upon the discovery I received, I would actually want to play the video that was provided me that involved the officers who issued the citation to Mr. Lyford. Obviously, I can't do that today by way of the Zoom hearing. So I would ask this court to set it for a trial date so I can present with laptop in the courtroom to play the video. I would also ask my colleague from the city to take the opportunity to review that video and listen to the words, the verbiage that was offered by the officers to Mr. Lyford at the time. I think that would be dispositive of count 1, which is the one count, obviously, from our perspective, we find acceptable.
And what I would like to have done is first of all, I'll say this, and this is as it relates to the city. I understand Mr. Morgan is really filling in. I would like to have this resolved today if at all possible. But I do understand that, and I'm not going to put Mr. Morgan on the spot because he is filling in today because our normal city attorney is out today. Mr. Morgan, let me ask you this. Is there any possible way, I know you're dealing with a lot of courtrooms, is there any possible way that you can take a look at this, or is that just like an impractical, it's not reasonable today?
What I can do is go back and consult with the officer and also look at our policies to see if there's any other room for an adjustment. And I'm not sure if the attorney, which attorney?
Well, I don't think that this is a policy. I don't think that this is a policy issue, and that Counselor Quas is saying that it's dispositive of what the allegations are saying. So I think what really needs to be done, and then you can let me know if this is even practical right now, and I understand that you can speak with the officer. Of course, you can do that. But I think what Counselor is saying is that the video in of itself, it has some things that lead to something that causes counselors to say that there should be a dispositive motion made based on what was said on the video by at least one of the officers. That's what, am I correct, Counselor, in that assessment?
You are
Well,
absolutely correct, Your Honor.
well, let me offer this, Your Honor. What I could do is to talk to, take Mr. Quast to a breakout room and see what he's talking about. Then I can go back and speak to the officer. I
Very well.
can,
If it's not practical, because we did have your office was not able, you're not the original attorney on this, so I can't expect you to have looked at this case, but if it's not practical, we'll set another trial date. But if it is practical and you guys talk about it, I'll give you an opportunity to work this out. If it's something you can work out now, then we'll work it out. But by no means am I gonna put you on the spot and rush you into something that you're just here for the day on, Mr. Morgan.
right. No, I appreciate that. I appreciate that, Your Honor. I would like to take at least about 2 minutes with Mr. Quast to see if there's any room for us to come to an agreement. And so before doing that, I'm sure you probably want to hear or see the other offers. I'm not sure if you just want me to bring the offers back to the courtroom.
Well, yeah, let's pass this matter and we'll give them an opportunity. Who are we ready on? Let's check those off.
Well, I mean, I've updated the offers on all the trials. Gilks, that's Tamika Gilks.
I don't think Tamika Gilks is here.
Okay, well, I was handed this file. And then Nicole Ousley.
Honestly, I don't think she's here either.
All right, we got officers on all those, I guess. Well, then there's a Janice Leonard.
All right, let me do this. Let me call, this is the city of Detroit versus Tamika and Gilks. Case number SP 11991. Five, 6, 1. Can you put your appearance on the record, Counselor?
Stephen Morgan on behalf of the city of Detroit.
And can you put your appearance on the record, Counselor Perkins Moore?
Linda Perkins Moore, appearing on behalf of the defendant.
All right. If you can get Mr. Corporal Holt and Corporal and Officer Nelson. I don't think Officer Brian Nelson is here.
No, he wasn't in the room. I can go and ask Hope to come out, Corporal Hope.
Come out right quick. We'll get him out of here right now.
Okay.
Gilks. No response. And I'm sure you don't have I'm gonna assume that you don't have a reason for your client not being here. Is that correct? Ms. Perkins Moore?
Yes, Your Honor.
All right, Corporal Hope, good morning. Can you put your appearance on the record?
Good morning, Corporal Kenneth Hope, Badge 444, Detroit Police 12th Precinct Station.
All right, very well. All right, so what I'm gonna do is I'm gonna issue a show cause in this matter. We'll see if we can find out where Ms. Gilks is and have her back in here, all right? Thank you for that. We'll close that out. FTA. All right, if it's no nothing further, I don't know if you have anybody else or not.
Oh, you're on today.
All right, have a good day.
You too, sir. Thank you.
All right, let's do Osley. This is the city of Detroit versus Nicole Renee Osley. Case numbers SP 1164320, counts 1, 2, and 3. Appearance for the record, please.
Stephen Morgan on behalf of the city of Detroit.
Linda Perkins Moore, appearing on behalf of the defendant.
All right, Ms. Osley, she missed a gift today because there's no, I don't see Officer Brian Nelson in the room. So we're gonna issue a show cause for her. All right, we will go ahead with the other offers, Counselor.
Oh, I have an offer here for Janice Leonard.
All right, what is Janice Leonard?
She's, I see her on the screen. The offer there is for her to plead to a 3-month delay on SP 111-88041. That's, I believe that's loud music or loud speakers. And then there's 3 other charges for a responsible plea. And those charges are SP 1106377, count 1. And then there's SP 1141235-1. And then there's also SP 111-8804-2. That would be count 2 there. Those 3 charges would be amended. Those are all moving violations. And they will be amended to limited access 1 to 5.
Each one of those?
Each one of them. And then there's, I'm going to recommend a dismissal on the remaining 6 charges that are on the docket. So if we're using a docket sheet, then we can call the numbers off. If you want me to call the numbers, I will.
No, I'm fine. I got the docket sheet.
I'm
All
sorry.
right, what about Arius Langley?
I'm sorry.
And you're
I
getting
couldn't
all
hear.
this stuff down, right, Madam Moore?
Yes.
Yes.
Go ahead. What about Arius Langley? What is the offer for this?
Oh, there, Langley, let's see. Aris Langley. That offer is going to be a plea to 3 charges. And those are guilty to SP 107-1301, count 1.
That guilty straight up?
Yes, it is.
No FTD?
No, that's a never acquired license. There's, let's see. Langley has 1, 2, 3, 4, 5, 6, 7, 8, 9. I have 10 charges on this docket sheet. There's going to be quite a few that are going to get dismissed. So the first one, never acquired license. That's the one I just read off. That's count 1. That's a plea of guilty. The next charge is SP 99. I believe this is 0704, count 3.
I only have one on that docket. On this docket for her. Let me.
For Aris Langley?
Well, just for that, you have a count. You have a count 3. Let me see what you're looking at on that.
Okay. 9907043. Yeah, that's the last. That's the last charge.
I see that. And that's the last one. So that is the seatbelt charge.
That something doesn't seem right with that SP 990704.
It's broken up on the docket sheet. 9907043 is down at the bottom, so it's broken up. All right, you have her pleading to that responsible plea for the seatbelt.
Actually, there must be some error there, because I had amended that charge, whatever that charge is, to an improper place. So I thought that was an insurance charge. There must be an insurance charge on there.
So that's insurance. I got improper plate then. That you're right on the 7041. That's improper plate, right?
Yeah, well, let me see, 7041.
That's the no insurance.
Correct. So I should just change that to 704-1. I don't know why that's there. Improper plate. And then there's responsible to an SP 107-1288-3. That's
no valid registration.
Is that what that is? Wait a minute, something's not right here. on my docket sheet. Let me look.
1071288-3 is no valid registration.
Okay,
That's a civil infraction.
right.
You want the responsible plea for that?
I think that's what I intended. Then I put down 88-1 and 2, counts 1 and 2. Okay, the expired plates and the insurance, those two are going to be dismissals. That's the SP 107-12881 and count 2. That's counts 1 and 2. Yes, so that is correct. The other two charges on that ticket would be dismissed, and then the one SP 107-1288-3 is responsible. No valid registration.
So far, I have two pleading the 2 misdemeanors and 1 civil infraction.
Yes, and that is it.
All right, let's go with, is that all that we have on, that seems like it. That seems like it will take care of everybody else.
I think what happened here was there were maybe have been a few officers that had not appeared, and I assumed that there was going to be a motion to dismiss. And see,
Ambrose is here.
so that's where there's a little bit of an issue. If Nelson did not appear, then SP 9907041, I know they would want to get a dismissal on that. That may be where there was some confusion with what I wrote. That's probably where I put where is it? That count 3. Oh, that's where the SP 9907043, that's a seatbelt, and that would be a responsible. So I would just actually change those. And
Yeah,
because we don't have Nelson. So that improper plates, I'm going to remove that. And then let me see. Oh, that's Nelson too. So I'm not going to do that either. So Nelsons are not on. So then it looks like there may be pleading to 2 charges, 1 misdemeanor and then 1 civil infraction.
All right, I have, the civil infraction will be the no valid registration, and then the driving while license never acquired. I have those 2. And then dismissing the rest, right?
Yes.
All right, all right. Now, I'm gonna put you now, I have, you have to speak with, Attorney Quas, and then, there's another issue that who's on the Galaxy A20 device?
I had to switch over because I couldn't hear nothing y'all was saying to me.
What's your name?
Janice Leonard.
Okay, very well. All right. Attorney Quas, you have to speak with, and then I have Attorney Sinclair, and this is another case, Attorney Sinclair, that we don't have the original courtroom prosecutor. This is a city case, correct? Or was this a state case? What did you have in here the last time that you spoke with? You're supposed to be working the South Court.
It was Alex Curry.
All right, he's gone. Let's get the state prosecutor on the line. So you deal with Attorney Quas, Mr. Morgan, and we're gonna get another state attorney on the line for you as it relates to this motion here, okay?
Okay.
All right,
and Judge, if I could get in that breakout room right now, because Judge Walker's calling me in for a human trafficking preliminary exam. So if I could see Mr. Morgan,
go ahead.
That'd be great.
Okay, that's on Linford, Colby Linford. Okay.
All right, let's go on.
So breakout room.
You got control of the room. Bring him in the room quickly so he can
You're gonna have to download
Okay,
that.
I only have an opportunity to get in breakout room 1. That's where the officers are. I think I'm not a co-host, so I'll just ask to be put in another one. Thank
I
you.
tried to co-host, but here.
4. Join 4. I'm going to 4.
No, 4.
All right, so let's get Miss Langley out of here if she wants to take the deal. We'll call her cases. This is the city of Detroit. This is the city of Detroit versus Arias Langley, case number SP 107-13011, SP 11-821762, SP 8737553, SP 990704, counts 1, 2, and 3. SP 107-1288, counts 1, 2, and 3. SP 11-82176. Appearance for the record, please.
Linda Perkins Moore, appearing on behalf of Ms. Langley, Your Honor.
All right, state your name, Ms. Langley.
Iris Langley.
You got to speak up now.
Iris Langley.
All right, the offer today is pleading to the driver's license never acquired straight up. And pleading to the no valid registration.
Yes, sir.
And the no registration would be a fine of $105.
On Thursday. Ms. Nash.
And the driver's license never acquired would be a fine of $240.
Yeah, for the
And with stipulation of probable cause, the other counts will be dismissed. Let me, if you need to speak with Ms. Perkins Moore in a breakout room, I can allow you to do that. I want to just look up and see what the abstraction would be for a driver's license never acquired, Ms. Perkins Moore.
Okay.
So we're gonna be able to hear you, not see you. So you're gonna connect with just your voice. All right? Yes, sir. Oh, you're welcome. You too, sir. Thank you so much. Diane, I don't know about the state. I'll try to call around and see who's our state prosecutor because we don't know.
Let's see, draw. I don't see profile license never acquired. Down here, license. First time I've seen them. License, alter, display, cancel, expire. License never obtained. Very 10.
Okay, they got this. Okay, fine. We don't have to say, we're trying to reach out to us, sorry.
Joel, while license not valid or improper license, that's a 2-point offense. That does abstract to the Secretary of State, and it is a misdemeanor. So just to give your client an idea of what she would be getting into if she chose to take this deal. And I'll fine her the $240. If there's any late fee or reinstatement fee, I'll waive those, but, and then the other cases will be dismissed. Ms. Langley, I can put you in a breakout room to talk to Ms. Perkins more about the offer, or you can take the deal. Today is the date and time set for a trial, and we're gonna get some kind of resolution today if it's needed from, and then you'll have an opportunity if you need to, Ms. Perkins, more to discuss this with the with the city attorney. Okay.
Breakout room 2.
I was just looking up that, the abstraction is a 2-point offense on that driver's license that required. I just wanted Ms. Langley to know that what she was getting into ahead of time. All right. I'm gonna put Ms. Langley in a breakout room, and discuss the matter. She's in the room now.
Your Honor, this is prosecutor by way of the update.
Okay, now who are we talking about?
By way of update on Kobe Ryan Linford or Lyford, I'm sorry. Mr. Quas went to another hearing, and I think he wants me to contact him on a cell if I can get a resolution that he would accept. So I was going to go ahead and try to see if I can do that. I need to get back in and talk to Officer Gaynor. And so
Are we objecting to setting this matter for another pretrial or something, or do you want to see if we can resolve it right now after you talk to Quas?
well, I just talked to Quas, and if I can get if I can get to an offer that he would find acceptable, then we can resolve it today. I was just going to take a couple minutes to talk to the officer and probably speak to Shannon on that, that drag racing charge.
All right, very well.
So I need to get back in. I need to get back into the breakout room with Officer Gaynor.
Can you tell Corporal Ambrose to come on out?
I will. Thank you.
All right, we're back on the record with Arius Langley. Corporal Rule, good morning to you, sir. Corporal Rule.
You call me, Your Honor? Officer Rule, you call me?
Yes, morning to you, sir. Can you put your appearance on the record? This is Arius Langley.
Officer Jeremy Rule, badge 3896, Detroit Police, 6th Precinct.
Thank you. And Corporal Ambrose, can you put your appearance on the record? This is for Arius Langley. Corporal Ambrose, can you unmute yourself and put your appearance on the record, please?
Corporal Brian Ambrose, badge 4151, Detroit Police Department.
Okay. What precinct, Corporal Ambrose?
12th precinct.
Very well. All right. So I just put that on the record. They're in the breakout room. going over the offer. I don't know if this is she's gonna take the deal or not, so if you guys want to stand by, I just wanted to make sure that you got your appearances on the record, all right?
Sure.
All right. Then we'll call Ms. Leonard next, and then we'll go back to cases. I have Grant, and then Face. What's your name, Face?
Robert Gribble.
Shakur Lockett.
Wait a minute.
Oh, my bad. I'm sorry.
Yeah, Robert Gribble is under Face.
Robert Griffin.
Gribble, Gribble.
Gribble, yes. And that was oh, you're waiting on Sinclair, Attorney Sinclair.
Correct.
All right.
Yep, I'm here, Judge. We were waiting for a state prosecutor. I think that's the last word that I heard from the court on it.
Yeah, we called, and I don't know if one is gonna come in. Now, again, all right, Ms. Perkins Moore, are you ready on Ms. Langley?
Yes, Your Honor.
All right.
Hello.
Which one?
No, he has not.
The judge, you can't get state.
You can't.
It's not in your agreement. You got my supervisor
They did, you did.
to find out who, what you should do.
Okay. All right, we're back on the record with Ms. Arias Langley. Ms. Langley, I've given you an opportunity to speak with defense counsel in the breakout room. Ms. Perkins Moore, what does your client want to do?
Yeah, Linda Perkins on behalf of Ms. Langley. She doesn't want to take the offer. She says she wants to have the matters rescheduled because she's waiting to see what the Secretary of State is going to do. Is that correct, Ms. Langley?
Yes.
All right, we're not gonna go there. It's a day, it's a date and time set for a trial. We gotta get some kind of resolution today on this matter. I don't understand why you haven't gone to the Secretary of State before.
I have. I had a ticket that just actually expired midnight on Friday night, and that was the only thing that was holding me back from getting them. So they just allowed me to take my test and get my permit and everything, and they allow me to have that for 30 days. So I figure if I can push this matter back, then I can resolve it a little bit better. Opposed to
Yeah,
me,
I tried to explain to her, but she has in her mind that if she waits a little while, she'll be able to go back to the Secretary of State and get her license. I explained to her that having a charge of driver's license never required, they're automatically going to give her a waiting period. She's not going to be able to walk in there and get a license, but she's intent on asking that the matter be adjourned so that she can wait, see what they do.
Right, they did give me a date on the matter, though. They told me I can get my license after 30 days of having my permit. So if I was to take this and say, okay, I'm pleading guilty to it, then I would feel in my mind would interfere with the Secretary of State have already told me, because they're not giving me answers based off of tickets I'm currently fighting. They're not gonna give me an answer until you guys knock your gavel and say, okay, she pled guilty to it. So I would like to see what I can do with a little bit more time.
Let me stop.
Thank you.
I believe you're correct, ma'am. I believe that this would affect your driver's license. Nevertheless, this is the offer that was presented. Now, what I will do is, and now that Ms. Perkins Moore has some more information regarding your situation, what I will do is I'll give her an opportunity to present that to the city attorney, and it's possible or not, to see if it's possible or not that he can take that under consideration and present another offer to you. But we're going to get some kind of resolution today. Really, in the scheme of things, you have 10 charges, and you're really only pleading to 2, and the rest of them are gonna get dismissed, so, you know, but your point is made, and it's a good point. And now that Ms. Perkins Moore has that information, I'll give her the opportunity to see if she can convince the city attorney to do something that may not abstract. Whether he does that or not, I don't know. But we're gonna proceed some kind of way today, all right?
Okay.
All right, so sit back. Once they get through their discussion, we'll get them back in the room. So just hold on, and we'll pass this matter. We're gonna call, now, you want to speak with Miss Janice Leonard right now, Ms. Perkins Moore, and you can discuss the offer and then see if she's willing to take that offer or what she wants to do.
Okay.
I got a 3-month delay and 3 counts of 3 counts of limited access, 1 to 5. Those limited accesses will not be abstracted on her will be abstracted on her driver's license, but it won't carry any points. And I'm gonna fine her $125 for each count. For the loudspeaker, I will dismiss upon payment of $240. So that's what will happen if she's willing to take that off.
Okay.
All right.
Yeah.
We'll let you speak during a breakout room, and then
Yes,
then you can discuss it, see what how she wants to proceed.
Yes, Your Honor.
Join the room now. All right, now, as it relates to your client, Mr. Sinclair.
Yes, sir.
There is, I'm told there's no, there is no there's no state prosecutor, the one that you spoke with. Did you ever get a resolution to it at all? Did you ever have an opportunity to speak with them during that time that I gave you?
Yes, the short answer is yes. We talked about it. We talked about it to the limits of Mr. Curie's authority, and he was needing to follow up with his superiors to find out what he could do to get authority to do what I was asking. And I didn't hear a response initially. Then I reached out again to find out what the results of those conversations were, and did not get a response. So, I mean,
did he ever tell you who he was going to speak with regarding that?
I'm sorry, say that one more time, please.
Names of his superiors that he was going to speak with.
No, I didn't ask the name of his superior. No, sir.
All right, because what we're having, I think Curry is gone from the prosecutor's office, if I'm not mistaken. Yeah.
Well, that would explain why he didn't respond to me.
Right, that's what I'm getting, Your Honor.
That would explain why he didn't respond to you.
Yes, sir.
I'm still of the belief, without having much more information except for reading the court rules, that this should be a 6,500 motion. That is because the time has passed, and that's why I wanted to send you off to the city attorney to see. So hold on, let me see what Grant has going on so we can get him. Let's see what Grant has. Can you hear me?
Yes, sir.
All right. All right, let's see. And this is what I looked at when you initially filed the motion. This is something that I looked at, but
Okay.
let's give Mr. Grant and see what he's got going on. And then we go to,
Did the court have an opportunity to look at the supplement that I filed on this matter?
no, I didn't get anything but what you had and you gave me at that time.
Okay, well, let me,
I didn't get anything else. You didn't, I don't think that you sent me anything to my email.
okay, well, my office should, well, I'll put it this way, my office should have sent it. I didn't personally send it, but excuse me.
I'll look at my emails and see if I overlooked something. That's a possibility, but let me call, all right, Mr. Grant, are you there?
Yes.
All right, Mr. Grant, you have 6 counts, 1, 2, 3, 4, 5, 6. And it looks like 3 of them are in default status. So it appears that they have messed your driver's license up because of that. Do you have a license, sir?
According to the Secretary of State, it's not suspended, but I'm waiting on today to get that corrected.
Grant, Terrence Grant, you're gonna
Okay,
get
yeah.
yours. Here, you can take this ticket.
Oh,
It is suspended. How old are you, sir? Mr. Grant,
Yes.
your license is suspended.
That's not what the Secretary of State said. And I got a letter from him.
Well, it's saying that now. That's as of today. Just now, we just ran it. All right. I'm believing that your license is suspended for, I'm believing that your license is suspended for these 3 issues. What I can do, I'll set aside these defaults and I will allow you an opportunity to go get to the Secretary of State and get a license, and I can get you back here on April 1st and we'll deal with these matters.
Okay.
You want to do that, or you want to wait on an offer today? I don't have an offer in the file for you right now.
I'll wait until April 1st.
All right, let's call the cases. This is the City of Detroit versus Terrence Eugene Grant. Case numbers SP 1141191, counts 1, 2, and 3. SP 1201689, counts 1, 2, and 3. Appearance for the record, please. Oh, there's no city attorney right now. So what I'm going to do is that since the defaults were had during the pandemic, the civil infractions were had during the pandemic, I'm gonna set aside these defaults.
Yeah, because the only reason I was waiting on.
Don't speak yet, sir. Just, I'm not even offering anything. You don't have to speak about it. I'm gonna set, Counselor, do you want to put your appearance on the record? You can, Mr. Morgan. But I'm on the record with Terrence Grant, and I'm setting aside his defaults. He has 3 civil infractions that were in default from the late 2020. I routinely set those defaults aside because of the situation with the courts and the pandemic and stuff like that, and the Secretary of State. So I'm going to set those defaults aside. I'm going to waive the late and reinstatement fee. It appears that this is what has suspended Mr. Grant's license. So what I'm going to allow him to do is I'm going to allow him to see if he can secure a license. There's not an offer in the file right now. So I was going to allow him the opportunity to see if he can secure a license and have him back for a pretrial on April the 1st.
Good, thank you, Your Honor.
All right.
April 1st.
Any objection to that, Counselor?
No objection, Your Honor. 2022.
All right, so we'll see pretrial at 8:30 for all the matters on April 1st.
And he's gonna bring all his
Okay.
documentation, is that correct, Mr. Grant?
Yes.
Thank you.
Bring all the documentation and hopefully you bring a driver's license on April the 1st, okay? That's the
Right.
most important, that's the most important thing. And as soon as we get this in here, I would wait 48 to 72 hours before I approach the Secretary of State to ask them for that license or to find out what's going on with it. Other than that, sir, if you have anything in any other jurisdictions, you better take care of those before you go to the Secretary of State, all right?
Okay.
All right, if there's nothing further, sir, I'll see you back April the 1st, 2022. And hopefully you bring a driver's license and some more documentation of insurance and stuff like that on that day.
Okay.
All right. Have a great day.
All right. Thank you.
All right, thank you, Your Honor.
All right.
Okay, Your Honor, by way of update, I've got Officer Stephen Gaynor here on the screen, and he is here on the Colby Linford case, or I think that's Lyford. I'm sorry. He's here on Colby Lyford, and I would just like to put him on call just in case we need him. But I do think we have a resolution for Mr. Lyford's case, and
All right.
we
call the case, right? Let's call the case. Let's put your appearance on the record. Good morning to you, Officer Gaynor. Can you put let's recall Colby Lyford. Didn't we call this case already, Ms. Williams-Law?
Yes, Your Honor.
the attorney is not here right now, Your Honor.
Well, the attorney isn't here, but we can at least allow Mr. Gaynor to put his appearance on the record. I want to make sure that his appearance is on the record no matter what. He can get paid today.
Thank you, Your Honor.
Thank you, Your Honor.
Can you put good morning to you, Officer Gaynor. Can you put your appearance on the record, please?
Yes, sir. Officer Gaynor, first name Stephen, Steven, Gaynor, Gaynor, badge 1658.
And department and precinct, please.
Detroit Police Department and 10th Precinct.
Okay, very well. We've done that. Now, do you have anything, so are we passing this matter until Attorney Claus comes back, Mr. Morgan?
Yes, Your Honor. I think that we're going to have to, because I believe we have worked out a plea based on my conversation with Mr. Quas. He's just he went to another courtroom and he gave me a telephone number. He gave me a telephone number to use to contact him. I will do that. But in the meantime, I just asked the court if the court would allow me to put Officer Gaynor on call because I'm not sure when Mr. Quas is going to come back.
Certainly.
Thank you. So, Officer Gaynor, I guess that'd probably be like a 10 minute call back. If I give you a call, we'll be looking to hear back to with the court. And if we resolve the case as consistently with what I told you about, I can just send you a message letting you know that the case has been resolved.
Okay, thank you.
All right, thank you. Okay.
Yep. Have a good day. Thank you, sir.
All right. Now, all right, we have, and we had an issue with, Miss Langley. And she brought up, something, that Attorney Perkins Moore was going to, and we'll just have this discussion off the record, Ms. Williams Law. Attorney Perkins Moore, I don't believe she's still in there talking to Ms. Leonard, but Ms. Langley indicated that, you know, the offer, while it being, I can't say that it's a bad offer, Mr. Morgan, but she indicated that she went to the Secretary of State not too long ago, and she gave me an expiration date of when the Secretary of State was going to allow her to get a driver's license. She brought up a point that if she pleads to this driver's license never acquired, then that probably will trigger another 1 or 2 year or however long suspension just automatically for that plea. So I believe Ms. Perkins Moore was going to address that with you, and she was going to see what kind of advocacy she was going to see if she can do on Ms. Langley's behalf as it relates to that. So that's that. I'll let her, when she comes in, if she wants to speak with you about it, I'll do that. Now, let's go back to Mr. Sinclair, and obviously these are conversations that we having without the ability to see what the city attorney's position is.
Right.
This is,
So Judge, my understanding of 6500s are that they relate or pertain to circuit court matters and felony matters. And I cited court rule, I think it's a 6.610 that relates to district court matters. And like I said, my understanding that's the main difference in procedure on these types of files.
6.610.
Yes, sir. And that was kind of the basis of the information that I included in the supplement.
That's not a matter for the city, is it?
No.
That's a state matter.
I believe it's a state matter.
Okay, good. I'm going to contact the other attorney in the meantime.
What other attorney?
Oh, that's Quas on the other case.
Okay, go ahead. All right,
Okay.
we're back on the record with well, we got Ms. Perkins Moore. We haven't called Leonard yet. We can go back on the record with Langley. I did kind of brief Mr. Morgan on what Ms. Langley said about the the further abstraction on our record. She indicated, and let's recall the case, and I'm going to allow her to put what she said on the record about dates, if you need to, Ms. Perkins Moore. But if you got that written down already, then that's fine. I can put you in a breakout room with Mr. Morgan.
Okay, breakout room with Mr. Morgan.
Okay, very well.
Do you want to do
No, wait a minute. I'm gonna let you speak with the lawyer. You speak with the lawyer, Ms. Langley. Don't speak to me.
Mm-hmm.
What breakout room for the prosecutor? You on 2?
4.
Okay, 4, got it.
All right, I'm looking at 6.610 and the criminal procedure generally in district court.
Yes, sir.
What actually are you citing?
Like I said in the supplement, I cited 6.610 subsection F, and 6.60 in my reading of the court rules is the district court equivalent to the 6500 section for circuit court or felony matter.
that last court rule 6.6. Okay, I got 6.610, that's subsection F, that's pleas of guilty and nolo contender, correct?
Right.
And now what else are you asking about?
No, I was just making a statement that my reading of the court rules that the 6600 section is the district court equivalent to the 6500 section for circuit court. And that's what I'm relying on to put this matter in a district court in front of Your Honor, district court judge, to raise the issue that I'm raising.
And essentially, I understand what you're saying about the defective plea.
Your Honor?
Yes.
Prosecutor agrees to adjourn the Langley matter, allow her to go get her license and come back, and then he'll redo the offer.
All right, so let's recall Arias Langley case. And what that's going to require Ms. Langley to do at this point is that's going to require Ms. Langley to come down and pay some reinstatement fees. And Ms. Langley, those reinstatement fees were going to have to be paid regardless of whether the case was going to be dismissed or not. And I'm going to give you what I'll do. I need that file too. No, I don't see any reinstatement. I don't see any reinstatement fees that she owes. What I'm going to do, if there is any reinstatement fees, it'll be on these civil infractions that are in default that should have been set aside. And they have been set aside.
Right, you set them aside. Last time I was here, you defaulted them, and then you gave me the opportunity to pay my reinstatement fees, and I did. And that's when I learned that I had one more ticket that expired at midnight on Friday. So that's why I was asking for more time, because I'm very, very close. As close as I've ever gotten.
It appears that the reinstatement fees have gone back in, or is this a payment that you made? Okay, payment.
I paid them. I paid them all.
All right, so, okay. So with that being said, you go ahead and if you want to speak, or if you want to speak with your attorney in the breakout room before you speak. But from my understanding, if you were eligible on that particular date, after that particular date, these tickets should not hold you up from getting a license. Because these tickets, there's been no abstraction put in the system. These are just mere allegations at this point. And this should not hold you up from getting a license.
The ones that are in my offer as already, or?
Yeah, none of these tickets today in front of me should have any bearing on whether you get a license or not.
I understand. I just also, if I could avoid the points, I would like.
Well, you're gonna. Well, but what they're saying is, you go to the Secretary of State, get a license, and come back, and then we'll deal with that at that time. But I don't think he's already gonna. It was Mr. Morgan here.
Yeah, yes, I'm here, Your Honor.
Okay, well, I believe the city attorney's position is he's already given you the Cadillac of office, and he's even willing now, since you came in, you've taken steps to go get a license, and you even gave a date. Put that date back on the record of when your license would be eligible for renewal.
I'm sorry, let me see, whatever Friday. So March 11th, I will be able to go and take my driver's test, and then I will be eligible to get my license within those days.
Okay, so March 11th, you're able to go get a driver's license. You might want to go March the 12th just to make sure. I don't know, but that's up to you and the Secretary of State. I don't think that these allegations here will have any bearing on you getting a driver's license or not. Because these allegations have not been abstracted to the Secretary of State.
Well, my
These
attorney just said that they would possibly keep pushing it back a couple of months, it might keep pushing it back.
Well, if you took the
Your Honor, I
deal
told,
today, go ahead, go ahead.
I told her that if she did decide to take the offer and got the points, even if they told
They're
her,
not going to give me my license. Don't look forward to getting my license. They're not going to give it to me
Stop,
because they're
man.
going to continuously push
No,
it on
Don't
me.
interrupt.
this is what I went through in the breakout room. Okay, Your Honor,
Don't
I tried to
interrupt.
explain to her
Listen
that
first.
she never acquired a license. And generally with the Secretary of State, when you have never had a license, they generally penalize you or put some type of time restraint on when you can get it. I told that it could be possible that if she did take this offer, she goes back, despite them telling her now, prior to this, that she would be able to get her license in 30 days, they may tell her something else. That's exactly what I told her.
And you told her that based on the fact that if she took this deal today, now, are you saying, Counselor, that regardless of whether she took this deal today, the fact that the allegations are out there, that it still could prevent her from getting a license potentially?
Yes.
Okay. Well, that's something, man, that you're gonna have to deal with the Secretary of State on.
Hey, right.
Where are you? You're on the phone. So, I mean, I don't think it's much more that the counselor can do, or the city attorney for that matter. I mean, I know you would probably wish all this stuff would just go away, but the only way that it'll go away today is if you plead to those things. Now, the city attorney, through the lawyer, your lawyer has been able to work out a deal so that you can go try, and we'll put this matter for another date. We'll hold that offer that's there and give you an opportunity to potentially get a driver's license. And if it messes with that, then I don't know what more anybody can do for you. Do you understand?
Yes, Your Honor.
All right. So how old are you, ma'am?
I'm 31.
All right. So, I mean, essentially, I don't believe, and this is just me, I don't believe that this stuff, these allegations should hold you up. But I do believe that if you pled to the driver's license never acquired today, that I do believe, and I'm almost certain that it would hold you up. So by your attorney being able to secure this offer and hold this offer until you come back and giving you that opportunity, you're not entering into anything today, you don't owe any reinstatement fees today, these just become mere allegations, then I gotta think, and I hope for your sake, that they do allow you to get a driver's license, because I believe that if you do get a driver's license, then that would push Mr. Morgan or the city law department to potentially do something a little bit better for you.
Right. That's all I'm asking for, Your Honor. That's all I wanted to be heard out on. Just a little bit more time in the same offer, if I can.
And you got that, and you got it. So I'm gonna give you till April 1st to come back. We'll leave the offer open as it is, and we'll have you back on April 1st, and hopefully you get that driver's license. That's what I'm hopeful that happens, because this is what we're here. We want to try to get everybody a license. So I'll have you back on first, and then we'll see where we're at that point.
Okay, thank you. And thank you as well for even deferring defaulting the license because of some of those tickets, because I wouldn't have been able to make it as far as I get. And I'm like, we didn't fight. I didn't get this far for me to mess around and reverse my own progress. So that's why I really just wanted to
nothing today is reversing your progress. Nothing today is reversing your progress. The only thing it's doing is just what the city attorney, based on the conversation that your lawyer had with them, they agreed to push this off and allow you to get a driver's license. So we're going to have you back on April 1st, 2022 at 8:30, and we'll see where we're at that point. All right.
Okay, thank you.
All right, have a great day, ma'am.
You all too.
All right, so that leaves, the officers are free to leave on that now. That closes that out. I figured you guys were gonna be free to leave anyway, but that does that. All right, what about Mrs. Leonard? Who was the gentleman with the iPhone with his hand up?
My name is Shakur Lockett, sir. I've been in here for a couple hours.
Don't tell me how long you've been in here, sir. I already know how long you've been in here. Everybody's been in here a long time. I've been here since before you got here.
Oh, yeah,
Was
that's not a
that
problem.
was neck roll on? Was that the same gentleman?
That was him.
Yes, ma'am.
So you know I remember him. And interrupting the court too.
Yeah.
I'm sorry. I didn't even know I just learned how to work Zoom. I'm sorry.
I'm not gonna believe that either, Mr. Lockett, but let's move on. All right, let's get Shakur Lockett's file.
Rhino, we're doing 11:25 for 10 minutes.
Okay, let's get Mr. Lockett out of here. This is the city of Detroit versus Shakur Lionel Lockett, case number SP 1198161. Appearance for the record, please.
Linda Perkins Moore appearing on behalf of Mr. Lockett, Your Honor.
All right, this is you haven't seen the allegation, but it's you know, and the offer is pleading to disorderly conduct. It's a urinating or defecating in public ticket, and the offer is pleading to disorderly conduct. I'll take it under delayed sentence. I'll dismiss the case upon payment of $240, or your client has a right to a trial. And what is I can get you in a breakout room, you can speak with your client, speak with them momentarily, and then we can get it. If the trial date will be April the 1st, 2022. If you want a pre-trial date to work it up and see what actually the allegation is, well, I read the allegation, but it just has that on there that I can give them that. That'll be May 1st, 2022 as well. I'm gonna put you in a breakout room, sir. Join the room and speak with the lawyer, please. All right. Miss Perkins Moore, what is Miss Leonard gonna do?
Ms. Leonard wants to avail herself of the recommendation, Your Honor.
Okay, we're gonna call that case then. All right.
Okay.
Speak to him. I'll let you put your appearance on the record. We're gonna see if we can get this done quickly. All right. Okay. Let you put your. This is the city of Detroit versus Janice Leonard, case number SP 110640001, SP 1117271, counts 1 and counts 2. SP 1118841, SP 1106377, counts 1, 2, and 3. SP 1118842, SP 1141235, counts 1 and counts 2. Appearance for the record, please.
Linda Perkins Moore appearing on behalf of Ms. Langley, Your Honor.
All right.
I'm sorry, Mr.
I need those files, Mr. Moore. All right, as it stands, Ms. Leonard, you'll plead to the, if you want to take this deal, you'll plead to loudspeaker ticket. I'll dismiss that based on a $240 fine. So that will be dismissed once you satisfy that, and plead to 3 counts of limited access, 1 to 5. Those are going to be $125 a piece. That'll be a 0-point ticket, but they will abstract to the Secretary of State. You want to take that?
Well, I'm sorry, excuse me. She wants to avail of the offer, Your Honor. However, she says she needs time to pay, and or if the court can offer community service.
I can offer community service, or I can give her time to pay, whatever she wants. Now go in that room. Ma'am, is that your understanding, that representation your counsel makes?
Yes.
All right, you can go in that room, Ms. Perkins.
Room 4?
Yes. I think we're gonna have to pass the matter briefly. I gotta give my staff a break. So then now is a good time for a break. Well, let's put Officer Hill, Officer Shabazz, and Officer Peacock, why don't you put your appearance on the record and I can let you guys go.
This for Leonard.
Officer Anthony Hill, badge 4598, City of Detroit, 10th Precinct.
Officer Abdul Shabazz, badge number 1194, traffic enforcement.
Officer Latoya Peacock, badge 3946, 3rd Precinct.
Very well. I've got you guys checked in, Ms. Williams Law. We'll let them go and we'll go off the record and come and we'll go in a brief recess, 15 minutes. Officers, you guys are free to leave. Thank you very much and be safe out there.
Right,
thank you. Have a great day.
All right, thank you.
Have a good day.
You think it'll be more than a couple minutes for you to finish this one?
I don't know how long it'll be. It's gonna be not too much longer, but that's up to you if you want to finish
Yeah,
up.
I had like maybe 2 minutes, but if it may go longer, I'll go ahead and just.
No, it's gonna go longer than 2 minutes.
Okay, thank you.
So go ahead and we'll take the break. All right. Now, do we have a supervisor for the state attorney's office?
Yeah, that's my supervisor, but I contact somebody from the state department because we don't know how to contact. I looked online, they sent emails saying I'm not the state prosecutor anymore. So we don't know what.
Is Curry still in that office?
He's not responding. I mean, I don't know if he is or not. He's just not gonna be our state.
Have you checked the bar journal, Mr. Sinclair?
Judge, my staff have been in contact with the prosecutor's office, and the one person that I had handling this matter went through whatever steps that she needed to go through to get the email address, and then that was provided to me, and that was the mode of communication that I was using.
I know you got Mr. Sinclair.
Yes,
I asked you a simple question. Have you checked the bar journal to see if Mr. Curry is still with the Wayne County Prosecutor's Office? Or has anybody from your office checked that?
No, I haven't personally done that. No.
All right. Well,
Information.
I wish you could do that. Let me do this.
All right, I'll look right now, Judge. I'll look. It gets kind of difficult to track down prosecutors when people leave and come back and switch dockets and hired, fired, whatever the case may be. And we try to the best of our ability to keep up with those changes, but there should be some two-sided responsibility.
Bar journal should be a place where you could kind of rely on that if they've done what they're supposed to do.
All right, I'm trying to look it up now.
His name is Kurrie.
Yeah.
Alexander Curry. Here he is, Assistant Prosecuting Attorney, Wayne County. So it appears that if he is still with the Wayne County Prosecutor's Office, unless he hasn't updated his bar journal license. Did you get this number 313-967-6026?
It's on my email. I don't remember it right now. I should look it up.
Well, the court got to it before I did, of course, but it does say he's still with the prosecutor's office, and there's no email on here that I see.
Why is it? Why is it so loud? Is that ringing on your thing?
No, you gotta turn the volume. Alexander Curry.
Hello, Mr. APA Curry. This is Judge Sean Perkins. I have Mr. Sinclair here. He had a motion and something regarding a client that there was supposed to be some discussion on, and I wanted to know where the Wayne County Prosecutor's Office position on it. You can give us a call back. We're at courtroom 313, number 313-965-2402, correct?
Yeah.
All right, maybe you can give us some insight on what's going on. All right, now, and you can give me, since I wasn't provided with the, information on your supplement, I don't have that, so I don't know what's going on and who is supposed to get that to me.
Where do you want it sent, Judge?
Send it to my email address,
What's your email address, Judge?
SEAN, period, PERKINS, at 36 District Court .org.
Thank you. I'll send it personally.
But while you're doing that, what am I supposed to be reading in this motion?
Well, the gist of the motion is that it was a defective plea that was entered on the initial date that this matter was resolved. The supplement will cite an amendment to the initial motion as to the court rule that applies to this situation. The court rule coupled with the case law that I found on it says that Mr. Gribble should have the opportunity to withdraw the plea and essentially put him back in the position that he was before the case was resolved. So that's why.
What is the court rule specifically that you're citing in that amendment as far as he should have that opportunity to withdraw the plea?
You said what's the court rule that says he should have that?
Yes.
I cited case law on that. The court rule just says what's required for the plea. And then the case law that I provided to the court says what happens if the requirements of the court rule are not met. And that's the reason that we, at least this is my perspective or understanding of the reason that we engaged the state prosecutor's office, excuse me, in order to see if there's an alternative resolution that could be reached.
That's what was supposed to be done this whole time.
And of course, I did my due diligence on it. I don't have a private investigator that I can send to track down prosecutors that don't respond to me. I mean, I'm not sure what else to do on those. This is not something that's, a one-off. It happens all the time where I have to try to track down a prosecutor.
You can go to their supervisors.
Okay. Yes, sir.
As simple as that.
Yeah, yes, sir. Great.
All right, we're just we're waiting on, the court reporter needed a break. So we're waiting on the court reporter to come back, and we'll get we'll get everybody out, Mr. Gribble. And
I need to step away for a moment.
Go ahead.
Okay, thank you.
All right, I'm going over this 6.610 subsection F on the guilty plea, and I that's the supplement I got that. I mean, the only thing I see.
Your Honor?
Yeah, you're back.
Yes.
Is there a, on that, right to, device or rights.
I can look one up though. Let me see if I can look it up. Okay, now.
And, Mr. Sinclair,
Yes.
I don't know if you have a court rules in front of you. Tell me why this isn't a case of actually a motion. Are you calling this a motion for a new trial, sir?
No, sir. It's a motion to withdraw defective plea.
We don't put this stuff on the record.
I can run across the trial service and try to see if they have one.
That's gonna happen. He's talking about. I see where why the motion is. I see where the alleged defect is happening. Really, my only reservation is there's gotta be some place about finality. It's gotta be someplace about why it's taken, well, let's just say 3 years because you came in last year, why it's taken Mr. Gerber 3 years to address this.
Judge, this is Mr. Gribble. Do you mind if I can tell you why it took this long?
No, you got a lawyer that's working, and a very good lawyer that's working for you, so.
And thank you, Judge. My perspective and my thought on that issue is twofold, actually. The appeals relate to, I don't know if I'm making up this word or not, but the obviation of a need for an appeal, or when it becomes obvious, or when the issue becomes noticeable. That's one part of it. And then the second part of it is, in my reading of the court rules, that the limitations on this type of motion are the same as the limitations on a 6500. Of course, we have the initial set of the initial time period for appeals, like to the Court of Appeals and things of that nature, as it relates to circuit court matters. But then again, my reading of the court rule says that once we go outside of that time frame, then that's where, as it relates to circuit court matters, the 6500 rules kick in, for lack of a better way to say it. And then as it relates to district court or like misdemeanor matters, that's when the 6600 court rules kick in.
I don't see where it says that.
No, you won't find those words explicitly in the court rules. And of course, the court is well aware that there is room for, reading, interpretation, understanding, filling in the intent of the court rules in circumstances where the issue presented before the court is not, explicitly stated, in the court rules. But it seems to me that
I'm looking at the court rules, and I do agree that it should say that, and that's why I asked you, why doesn't the motion for a new trial, why doesn't that give your because of course your client should have some redress if there's been a fatal error in the plea. We're beyond that, right?
Okay.
But the question is, how does he redress this issue? And at what time period does it become a case of yeah, there's an issue, but your client never addressed it within a proper time? And the redress that I see that's clear in 6.610, and I'm not saying that this is necessarily the only redress, but what I see in the rules here is a motion for a new trial. That would so a motion for a new trial must be filed within 21 days after the entry of a judgment. However, if an appeal has not been taken, a delayed motion may be filed within the time for filing an application for leave to appeal. Now, go ahead.
No, I was going to say the reason that I didn't file a motion for a new trial is because, again, and I'm trying to be explicitly clear. This is just my reading of the court rules. Is that that rule wouldn't necessarily apply to this situation because it was a plea. Like he didn't initially go to trial, and then the rule that I cited seemed to apply in my view, and the case law seemed to apply in my view because it just the consequence of the defective plea puts the person in the position that they would have been, before the plea was entered. And I didn't find any rules as related to, time limitations and things of that nature. And of course, that was a consideration, when the matter came to my office. But like I said, I didn't see anything that limited or that banned the opportunity, if I could say it that way, for the filing of this motion based on time alone.
All right, are we back, Ms. Williams-Law? Okay, we're back. All right, let's get Ms. Leonard, see what happens with Ms. Leonard's case. What happened to Mr. Lockett? What does he want to do?
Mr. Lockett is continuing his plea of not guilty and requesting a pretrial date.
Okay, where is he? Is he in the room?
Yes, sir.
Here, so, all right, let's go back on the record with Mr. Shakur Lockett. I'm gonna, is that the case? You want a pretrial date in this matter, sir?
Yes, sir.
All right, I'm gonna give you a pretrial date of April the 1st, 2022 at 8:30 a.m. Let me, what should we expect on that pretrial date? Take your hat off, sir.
That's not me.
Who's got their hat on in the Galaxy A02s?
I don't know.
What should we expect on that pretrial date, Ms. Perkins Moore?
Yeah, we're going to give the opportunity to see if we can talk to the prosecutor about another offer.
All right. You want to just set a trial date?
That's, you know what, Yana, when you said pretrial initially, I would prefer a trial date than the officer would have the opportunity to appear.
All right, we'll give you a trial date. We'll leave the offer open, sir. Come back on April 1st. We'll call it a trial date.
Your Honor, in regard to the show cause, I'm not sure if he's been arraigned or not, but if he has not, he wishes to stand mute, waives a formal reading.
Okay, we'll enter a not guilty plea on your client's behalf. We'll continue a $0 bond, and we'll give him a trial date of April the 1st, 2022. All right.
All right.
All right. There's nothing further. So have a great day, gentlemen. With the Galaxy A02s, take your hat off. Let's get Miss Leonard on her way. We'll recall the case of Mrs. Janice Leonard. Ms. Leonard, I've given you an opportunity to speak with Ms. Perkins Moore in a breakout room. Ms. Perkins Moore, the offer was pleading to one count of delayed sentence on the, I believe that was the disorderly, the loudspeaker ticket, and then 3 counts of limited access, 1 to 5 over, and we'll dismiss the remaining counts. What would your client like to do?
She would like to avail herself of the recommendation, Your Honor, and tender a plea. And I indicated earlier that she was requesting that the court could give her community service in lieu of the court cost and fine.
You did, and we will definitely give her that opportunity. Ms. Leonard, are you there?
Yes, Your Honor.
You want to take that deal, ma'am?
Yes, Your Honor.
All right. Ma'am, I need to see you. Where? Okay, can you raise your right hand, please? The other right. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, you can put your hand down, ma'am. Ms. Leonard, do you understand that the maximum possible penalty is 93 days in jail and or $500 in fines for the misdemeanor cases?
Yes, Your Honor.
You understand that you have a right to a trial?
Yes, Your Honor.
And let's go through this plea agreement and start adding this to our. You have a right to the assistance of attorney?
Yes, Your Honor.
You have a right to plead guilty or not guilty or stand mute?
Yes.
You have a right to attorney at the public's expense if you cannot afford one yourself?
Yes.
You have you may have to repay the expense of the appointed attorney. You may contest your ability to pay the ordered fees, and the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following right: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify, to be presumed innocent unless proven guilty beyond a reasonable doubt. You understand that, ma'am?
Yes, Your Honor.
If you have a plea, if you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind and will give up the rights listed in items that I just listed above. You understand that?
Yes, Your Honor.
You have a right to be released on bond. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by judge or jury, it may result in violation of your probation or parole. You understand that?
Yes, Your Honor.
You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to circuit court may be taken within 21 days from the date of sentence or as permitted pursuant to, here we go, Mr. Sinclair, you need to listen to this line, 6.625B, if the sentence includes incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days after sentencing. You understand that, ma'am?
Yes, Your Honor.
And you still want to take this deal?
Yes, Your Honor.
All right, let me draw your attention back to September 29th, 2020 at around 1:50 p.m. in the city of Detroit in the area of Woodward and Delaware Street, ma'am. Did you have an occasion to be pulled over by a Detroit police officer on that day?
Yes, Your Honor.
All right, and on that date, were you operating 2004 Buick?
Yes, Your Honor.
And was the music blaring out the speakers of that car, ma'am?
Yes,
All
Your
right,
Honor.
I'm gonna find you guilty of the account of loudspeaker as charged, and I'm going to sentence you to $240 on that and/or community service. As for relates to the civil infractions where your client stipulate to the basis of the tickets as an accurate factual basis for the responsible plea on those matters.
Stipulate, Your Honor.
All right, with that stipulation, I'm gonna find you responsible to the amended counts of limited access, 1 to 5 over for case number SP 1106377, count 1. Well, and SP 1118804 and SP 1141235 So limited access. With stipulation of probable cause, I'm going to dismiss all the other matters.
Stipulate, Your Honor.
All right. Ma'am, you need, I'll give you an opportunity to pay, or I'll give you an opportunity to do community service. Based on what I see here, that community service is going to 125 times 3 plus 240. That's going to be 30 hours of community service. If you want to do that, I'm going to give you $20 an hour toward community service. If you can do all or part, you tell me what you want to do, ma'am.
Yes, Your Honor. I'll take the community service.
All right, 30 hours community service. Let's get you to Mrs. Green. You have an ink pen, ma'am?
Yes, ma'am. I mean, yes, sir. Yes,
All right,
Your Honor.
All right, write this down, 313-965.
313.
965 8130.
8130.
8130, yes.
Can you say her name again?
Miss Green.
Miss Green.
Yes.
Okay.
All right, how long do you think it's gonna take you to get that community service done now?
I don't know. I'll call Miss Green and find out when she need me to start.
No, I gotta get a date now.
By
like-
April the 16th. How about by March the 16th? Yeah,
You've
April
been listening
16th.
to that date, huh? Community service. You've been listening to that date, huh?
Yes, it's been repetitious all day.
April the 18th, and I hope it's April the 18th because I messed up. It's supposed to be April the 18th instead of April the 16th. So we're gonna have some problems with some people moving down the line. 30 hours of community service. We're gonna generate an order for you to do that community service. And I'm going to dismiss the matter of the loudspeaker upon completion. Dismiss upon completion.
Okay.
So if you let us get that order and call Miss Green up in at least 2 days. Let her get that to her desk. If she hasn't contacted you before Thursday or so, give her a call, okay?
Okay, Your Honor, so I could do community service anywhere, or I gotta do it designated where y'all place me?
Yeah, talk to Miss Green. You gotta do it where Miss Green wants you to go.
Okay.
All right. If it's nothing further, ma'am, have a very good day, all right?
Your Honor, I would just like to thank Ms. Leonard for the homemade chicken soup recipe. Thank you, Ms. Leonard.
You're welcome. You're welcome, Ms. Perkins.
No, I'm mad now.
That's my recipe.
Wait a minute, let me bring all this stuff back. You're gonna need a a couple of lawyers now on this, Miss Leonard.
She
All right.
said, Bob recipe.
All right, all right, good luck on that, good luck on that community service. We'll have you back for a review, and then at that time, you can let us know what you did and how you felt about it, and we can make sure this stuff is closed out.
Thank you, Your Honor. Y'all have a blessed day.
Thank you for your
You're
patience.
welcome,
You
Ms.
do the same.
Perkins.
Bye.
Bye.
All right, let's go. Who is on that Galaxy A02s?
Now how do I leave the courtroom?
No, not you, Miss Girl. I'll put you out. Mr. Lightford has his hand up.
This is Mr. Green.
Yeah, I'm waiting on your lawyer to come back. Mr. Lightford. All right, Mr. A02S, what's your name, sir?
This Denzel Green.
What is it?
Denzel Green.
Green. It's not Devon Green, is it?
No, Denzel Green.
Denzel. He's probably on this afternoon. He's probably here early.
Yeah, I'm supposed to be in court at 1:30.
Oh, okay.
All right, come back at 1:30. I would take you, but we're running over. Come back at 1:30. You get here first. I'll get you out first. All right.
All right.
All right. Have a good one. I'll see you at 1:30.
All right.
All right. All right. Now, does that help you out? Any further insight on that, Mr. Sinclair?
So I read, as the court was handling the last matter, I did read 7.105 G2C. And I'm going to go back to it because I've been scrolling since then. And the initial rule that the court, well, one of the other rules that the court read was, I think it was 6.265. And that seemed, in my view, to apply to situations when there's a sentence to incarceration. So that doesn't apply here. And I'm scrolling back to get to the other rule. 1 second, please. And my reading of the 7.105, it seems to me it makes a distinction between like a motion for new trial and a motion to and a motion to withdraw a plea. And 7.105 G2C makes a statement, says an order denying a motion for new trial under 6.610.
Stop. Let me catch up. I just read 6.625. What are you saying now? Applies?
Okay. So my reading of it, it seems that applies if there's a sentence of incarceration. And
I see where you see that on 6.625, right? That
Yes,
is an appeal from a misdemeanor case is governed by subchapter 7.1. That's the initial court rule on A. Then B goes to speak to if the court impose a sentence of incarceration, then they talk about having an appeal lawyer appointed to that individual. Even if suspended and the defendant is indigent, the court must enter an order appointing a lawyer if within 14 days after sentencing. So those two issues are kind of all right. Let's get Quas out of here, and then all right. Let's go back on the record with Mr. Kobe Lightford. Mr. Quas, I guess there's been some sort of resolution. Is that your understanding?
That is my understanding, Your Honor. Thank you.
All right, and what is that? You want to put that on the record, sir?
Your Honor, my understanding of the agreement, there are 3 separate violations in the citation. The first 2 would be dismissed pursuant to a plea of responsible to the third one, which is the disregard of traffic signal. Upon the acceptance of the responsibility for that offense, the drag racing and the unregistered vehicle would be dismissed.
All right, and I'm just gonna go off of, I don't have the city attorney in here, so you're an officer of the court, and I'm gonna accept your representation as that is the case.
Thank
Now,
you.
Do you need to speak with your client in a breakout room?
I do not, Your Honor. I communicated with him by text. He's in agreement, and I will speak on his behalf and accept responsibility as to the civil infraction based upon the dismissal of the other two charges.
All right, is that your understanding, Mr. Life?
Yes, Your Honor.
With that being said, I'm going to, can you raise your right hand, sir? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Well, you know, and Mr. I will say, Mr. Sinclair, the court, when you brought this motion initially, has amended the way it does things and asking those right to a trial and stuff like that. And then now I'm gonna go even further and read the advice of rights form, because that's what the court rules say for each individual defendant. However, in this case, Attorney Quast, the fact that your client is entering a responsible plea instead of a misdemeanor plea, does your understanding of the rules, does that necessitate me going through all of this advice of rights and stuff like that?
I do not believe so, Your Honor, because responsibility and his acknowledgement of responsibility, that satisfies it as a civil infraction.
Okay, and that's my understanding as well. You're not pleading to a misdemeanor, sir, and as a matter of fact, those are allegations that the city attorney is now, based on your plea to the civil infraction, is taken off the table. So what we'll do is, Attorney Quast, do you want to stipulate to the face of the ticket as an accurate factual basis for the responsible plea?
So stipulated, Your Honor.
And is that disregarding a red signal? Does your client understand he's going to be entering into 3 points on that?
He does, Your Honor.
All right. And you understand that, sir?
Yes, Your Honor.
All right, so I'm going to find you responsible as charged to the disregarding a red signal ticket. It says here accident 361. I don't know if that is the correct, well, it's 257.612 paren 1. That's how it's listed on this ticket. Traffic control signals, when traffic is controlled by traffic control signals, not fewer than one signal shall be located over the travel portion of the roadway so as to give vehicle operators a clear indication of the right of way assignment from their known positions approaching the intersection. The vehicle signal shall exhibit different color lights successively, one at a time or with arrows. Red arrow and yellow arrow indications have the same meaning as the corresponding circular indications, except that they apply only to vehicle operators intending to make the movement indicated by the arrow. The following colors shall be used, and the terms and lights shall indicate and apply to the vehicle operators as follows. I won't go through those things. subsection 1 or 2 as civil infractions. It says that the caption control location red, girl, yellow, indicator, stopping a sign for civil infractions. Okay. So that is a civil infraction. I have a cost down here of $170. And what I'm going to do, the cost is going to be $130, sir. And that's going to be what it appears here is, it says 2 points on your license. But I thought disregarding traffic control device was actually 3 points on the license. I'm going to give that information right now so you can be informed of that.
Your Honor, if I may, my understanding is traffic control device is 2 points. Traffic control signal is the 3 points.
There you go. Okay, so this is going to be the 3-point offense then. Disregarding traffic control device. All right. So, well, I'm going to find you responsible as charged. I'm going to fine you $130 for that. And I'm with stipulation of probable cause. I'm going to dismiss the other 2 counts. Can I get that stipulation, Counselor?
So stipulated, Your Honor.
All right, very well. If there's nothing further, sir, when can you pay?
I could pay anytime, truthfully. I do work today. I don't know if I have to come in person. If so, today probably wouldn't work.
I would just say pay that at any DivDav kiosk in the city of Detroit.
Okay.
Or pay that online. Not online, I'm sorry, pay that in person. That's to be the best ways that thing is get immediately on the record. I'm gonna give you till March the 7th to have that taken care of. Online has been taking quite some time and it's been delayed. I want to be able to close this out by March the 7th, all right? So I'm gonna set a review at 8:25 and I am going to have you back then if you haven't paid. If you paid, there's no need to come back, all right?
All right, I appreciate it.
All right, have a great day, sir. And you, Mr. Foss, as well, have a great day.
You as well. Thank you.
Pleasure to appear in front of you. Thank you.
All right, thank you. All right, now let's go put, let's put Gribble on the record and we'll see what we're gonna do. Let's just do this and then we'll call it a morning. Oh, it's gonna be an afternoon. We'll call it a morning. This is the city of Detroit versus Robert Rashad Gribble. Case number SP 8128381. Appearance for the record, please.
Good afternoon, Judge. I'm Christopher Sinclair, P80512, appearing with and on behalf of Mr. Gribble, who's present on Zoom, and he consents to proceeding this way.
Okay. All right. Now, we had a lot of discussion about off the record. We don't have, let me indicate that we don't have a prosecuting attorney. And we've given them an ample opportunity to come to this hearing. Mr. Gribble has been waiting. I had this case set for a pretrial today in the hopes that, there was something that would been able to been worked out. But that hasn't been done, and I'm not putting any fault on your office, Mr. Sinclair. You filed the motion, and the other counsel was here at the time. I even called that counsel on the phone to find out where that counsel is. It appears that counsel is still working for the state prosecutor's office, and just because that counsel is not in this particular, maybe not be in this, if he still is at the state prosecutor's office, just because he's not in this particular office that comes into my court, does not really relieve the fact that he's not here. However, you know, what I want to do is really, I want to get it right. That's the most important thing. First of all, I will say this: I'm confused to say why this incident is on my docket, because it's a improper plate. Now, I do want to get it right, and I'm going to allow you to speak to some of the stuff that we talked about off the record as far as procedurally and how this is done. Mr. Sinclair, is there any, you want to put something on the record as far as the court rules are concerned, or maybe what you have learned now?
Yes, sir. So just briefly, my reading of the court rules is that this matter is governed. Well, let me start here. Procedurally, this matter was initially in front of Judge Kenyatta Jones, and now she's on, of course, the felony docket. So I believe it was routed to Your Honor's court because of that fact, and maybe just reassignment of judges on different dockets. My reading of the court rules says that 6.10, section 6.1, 6.610, excuse me, applies to this matter in the way that 6.500 applies to circuit court matters, as a circuit court matters, felony matters, and things of that nature. The court did bring to my attention that these appeals are governed by 7.100 as dictated by other sections of the court rules, and there appears to be some distinction or differentiation based on the type of motion that is filed. That 7.105 definitely speaks to motions for new trials and things of that nature. But in my view, in my reading of the rules, a motion for a new trial wouldn't necessarily be appropriate here, because this was a conviction by a plea and there was no initial trial. And this, the motion before Your Honor is a motion to withdraw a defective plea. And I think the court agreed that 6.610 kind of outlined the requirements of a plea. And then I think our opinions may have diverged slightly as it relates to the relief that is to be granted or allowed, excuse me, if I can say it that way, the relief that can be allowed based on a defective plea or a plea that does not follow those court rules. And at this point, I'm happy to, well, let me go here first. I keep interrupting myself, which is kind of weird, I guess. I did try to follow up with Mr. Curie, who is the state prosecutor who was initially on the file. You know, I thought we were making headway on it. I followed up with him after the court hearing to you know, kind of find out where his office was on that matter. And, you know, there's varying information as it relates to his status with the office or whoever was reassigned to this particular motion. So at this point, I guess the only thing I can say is I'm happy to file a supplement that addresses, you know, any outstanding or like specific issues that the court wanted me to address. And at the same time, I guess we can put our efforts together to track down the state prosecutor who's assigned to this case specifically, in the absence of Mr. Curie.
All right, a 7.1. There's 7.101 appeals to circuit court. This is the subchapter 7.100. Scope of the rules. The rules in this subchapter govern appeals to the circuit court. Rules do not affect jurisdiction as B. All right, and then when you go to the definitions, the purpose of subchapter agency means any governmental entity other than a trial court. Appeal means judicial review by the circuit court of a judgment, order, or decision of a trial court. Would you agree that this encompasses 7.102 paren 2?
If I can have 1 second to get to that, please. So I would agree that that's the definition of appeal, but I would disagree.
Let's just take this one step at a time.
Okay.
If this was this an order, a judgment, order, or decision of a trial court? I don't think there's any. Ms. Perkins Moore, if we're done for the morning docket. If you want to leave, unless you want to hear. All right. Thank you for everything.
And Judge, to that last question, I would disagree. This was not a decision by a trial court. This was a decision by a district court judge.
That's a trial. This is a trial court as well. We're just a district trial court. We handle matters that up to 1 year in prison, misdemeanors, or and as far as criminal cases are concerned. So I don't think there's any dispute about this being a trial court. Do you?
My response was and is based on the idea that it's usually, I guess is my way of thinking. I don't have a court rule to substantiate that. It's just that the trial court is usually, the way I use it, is a circuit court. But looking at the definition under 7.1029, subsection 9, 7.102, yeah, that's right. Subsection 9, then a district court is technically a trial court.
Yeah, you're just in the circuit court more times than you are in the district court, and you hold trials there, but trials are held here as well. All right, now let's move on. Who's on that phone? I need to learn how to lock this room, Ms. Williams. I'm gonna make you the co-host. And maybe you can lock this room. That person on the phone, who's that on 551-1375?
That's Mr. Gilliam.
All right, Gilliam, you gotta come back.
I already spoke to him.
Oh, you did? What did you?
He got 217 to come back.
Come back on the 217, sir.
All right, okay. I was just trying to save my job and get me some temporary license. But this is Judge who? Referee who?
Perkins, you want to come back this afternoon?
They told me to call you guys today, but I didn't mean to interrupt.
Come back on 217, sir, on Thursday.
Thank you.
Thank you. All right, so we got that established. Appellate jurisdiction of the circuit court, appeal of right. This is 7.103. The circuit court has jurisdiction of an appeal of right filed by an agreed party from the following: a final judgment or final order of a district court or municipal court, except a judgment based on a plea of guilty or no low contender. A final order or decision of an agency governed by a final order decision or an agency. Leave to appeal. The circuit court may grant leave to appeal from a judgment or order of a trial court when no appeal of right exists, or an appeal of right could have been taken but was not timely filed. So based on these rules, from what I'm reading right here, is that you're in the wrong venue for this. Do you see where I'm coming from?
So if we look at 7.103A, A1,
7.103A is appeal of right. The circuit court has jurisdiction of an appeal of right filed by an agreed party from the following: a final judgment or final order of a district or municipal court, except a judgment based on a plea of guilty or nolo contender.
and that's
A
what we have.
final order. Okay, that's the exception. Then you go by appeal by leave. The circuit court may grant leave to appeal from a judgment or order of a trial court when no appeal of a right exists.
I think
Now, go ahead.
I think this court gets jurisdiction under 7.103A1, the exception, because this is a judgment based on a plea of guilty.
I think that you're reading into that.
Now, I think that's exactly what it says. Like that, for me, that's not an interpretation issue. That's exactly what it says. That the circuit court has jurisdiction, except if it's based on a plea of guilty.
Except when it's based on a plea of guilty, right?
Right.
Yes, that's the appeal of right. That's the appeal of right. So just like your client gets, goes to trial, and your client goes to trial and gets found guilty at trial, that client automatically has a right to appeal that. But when your client takes a plea in any court, circuit court, let's put it to circuit court, which you're more used to. If your client takes a plea, that plea does not automatically grant him that appeal of right. He has to file leave for appeal based on his guilty plea. And this court, or that would go to the appellate court for the leave to appeal. And if you're in a circuit court matter, in this court, that would go leave to appeal from a district court to a circuit court, and to say, I know I don't have the appellate court right because it doesn't give me that right. That's what that exception is saying in 7.103A1. It doesn't give me that right to appeal, so I have to go down and apply for leave to appeal.
Right. So what you're saying, and I'm agreeing, is that 7.103A does not apply to this situation at all because it's not an appeal by right.
Right.
Okay.
Now you go down to 7.103B, leave by appeal. The circuit court may grant leave to appeal from a judgment or order of a trial court when no appeal of right exists, or an appeal of right could have been taken but was not timely filed. So whether a plea of right could have been taken in this case because of what you're saying, a defective plea in and of itself. And here's what the issue is narrowly, right? When you break it down, and I'm not saying you're right or wrong, or whether it's right or wrong, I'm saying the court needs some more guidance. You're narrowly saying, hey, judge, I wouldn't even be here had they read my client the court rules as it's supposed to be done in 6.610.
Yeah. And
Right.
then given statutory maxes and those types of issues.
Right. I get that.
Mm-hmm.
Go ahead.
Judge, if I may insert this, it says, let's see, 7.103B, the first line says the circuit court may grant that leave to appeal, but I didn't run across any court rules or maybe I just didn't see it where it says that because the circuit court can grant that leave to appeal, that the district court does not have the right to withdraw a defective plea, as is the case in this situation.
And I'll give you that. You're exactly right. I don't see that either, and I don't know. And put it this way, I'm going to say I don't know.
Yes, sir.
I don't know. And this is what this is where the court is held up on and so let's I don't know, put it this, I don't know what your client is ultimately, where he's ultimately trying to go on this. I don't know that, and I don't know if that even matters. You know, I don't know if I do know that the state attorney's office was supposed to be on this, and I really want to hear from why they are not here.
Right.
All right, if your motion is granted, where is your client gonna go with this?
And Judge, just transparently, is based on Mr. Gribble is trying to drive for, I think it's Uber, I believe it is one Uber or Lyft or one of those or both of those situations. It's my understanding that pursuant to their policy, there are items that a person can have on their driving record and items that cannot be on the person's driving record. And as it stands right now, this is a newly raised issue as of the time that I filed the motion. The item that's on the record right now is preventing him from earning income with those companies. And it was just, recently brought to his attention.
I wish that was told a long time ago to the court. And I appreciate your diligence. I don't understand now. And I'm willing to grant your client some relief.
Okay.
What I would do in this matter, what is my authority? And you can look it up and come back this afternoon. I believe I have the authority to resentence your client. I don't need the state attorney in here to do that. And I've done it in the past because, and the reason why I think it's in the interest of justice, your client was pled guilty on October 26, 2018 to amended count of improper plate. In today's world, the offer is to plead to that, pay the fines, which would be $240 in my court. I see he paid $265 on that date. He has paid that and satisfied that, and I would dismiss upon payment.
Yeah, so the court does have authority to do that, and I'm almost 100% confident that Mr. Gribble would not quibble, no joke or pun intended right there, but wouldn't quibble with the opportunity to earn a dismissal upon payment. And that's the charge. That's the only charge that he pled to.
All right, so what do you want to do with this motion in front of me, counselor?
If we can do that, then I will withdraw the motion.
All right, I'm going to accept, I'm gonna allow you to withdraw the motion. And counselor, it's on you now.
Yes, sir, and I appreciate that. I would ask the court to resentence Mr. Gribble in this matter in a way he's pled to. Shoot, I don't have the paperwork in front of me. He pled to
improper plate.
On October 26, 2018, he was fined $265. It has here that he owes the court no monies as it relates to that. He satisfied his agreement on that.
Yes, sir. So with that said, I'd ask the court to dismiss the matter because Mr. Gribble, and this, assuming this is a resentencing, I'd ask the court to resentence Mr. Gribble in a way that dismisses the case upon payment.
in here, looking at the register of action, we went through all of that, sir. And I won't say it's for nothing, because we can always learn something as far as these rules are related to. But I have on 8/2/2021, motion to withdraw, okayed by Brian Ward. Whoever Brian Ward is. So
No idea.
It's kind of the same effect, in that, it's kind of poses the same effect. So what we'll do, let me see who Brian Ward is. I'm gonna look up in the court rules,
In the bar journal.
in the bar journal. I'm gonna look up in the bar journal and see who they're talking about, Brian Ward. I gotta think that this must be some representative of, the Wayne County Prosecutor's Office. Because if there is a stipulation to, I don't see Ward.
The last name is WARD.
That's what I have here on the register of action.
Oh, I'm not seeing that person.
And I guess, I don't know, motion was sent to. So it's 6 in one, half dozen in the other.
Right.
Do you want me to grant the motion? I'm gonna assume that Brian Ward is a representative of the Wayne County Prosecutor's Office, because you don't know Brian Ward. You didn't,
Right.
This was not coming through your office, is it?
No, sir.
All right.
And Judge, I'm sorry, go ahead.
Go ahead.
Now, I was saying I'm perfectly okay. Like, I don't have any hangups about, withdrawing the motion versus not. My goal is to get the relief that Mr. Gribble is asking for. And the last kind of course of conversation or that the court and I were having, I think it helped we resolved the issue that caused me to file the motion, put it that way. So I don't have any issue with withdrawing the motion and continuing in that vein.
Okay, all right. Well, let's do it this way then.
Okay.
Let's do it this way. Let's grant your motion to withdraw the plea.
Okay. Thank you.
And now it puts us back to square one. And your client, will your client accept the new offer of improper plates, amended to improper plates dismissed upon payment of fines and costs?
Yes, sir. And that's correct, Mr. Gribble, right?
Yes.
Okay. All right, Mr. Gribble, can you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down, sir. Sir, you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines.
Yes.
You understand that if the plea is accepted, the defendant will not have a trial of any kind, and that the defendant gives up the following rights that the defendant would have a trial. The right to have witnesses called for the defendant's defense at trial. You understand that? You're giving up that right by taking this plea?
What will the plea be again? Can you repeat it for me?
It'll be to plead to the amended count of improper plates. I'll fine you the $265 that you've already paid, and I'll dismiss that immediately upon payment. So
yes, I agree. I agree to that plea.
Well, do you agree, the right to, because, now that your astute attorney has come in and made these motions, now the court is gonna make sure that from this point on, we go through all of this stuff so that you know. And not to say that he couldn't have figured out some other way to get it done, but you see how hard he's worked on that, right?
Appreciate it.
All right, so if the plea is accepted, the defendant will not have a trial of any kind, and that the defendant gives up the following rights that the defendant would have at trial: the right to have witnesses called for the defendant's defense at trial, the right to cross-examine all witnesses called against the defendant, the right to testify or to remain silent without an inference being drawn from said silence, the presumption of innocence, and the requirement that the defendant's guilt be proven beyond a reasonable doubt. Do you understand that you're giving up those rights?
Yes.
And then subsection 4 orders the court, the defendant or defendants may be informed of trial rights listed in sub rule 3B as follows. And it allows me to, in writing, make part of the file, which we can't do because you're not here, or in writing reference to on the record, which we can't do because you didn't put it in writing. I can't provide it for you on writing, so I'm going to put it on the record. All right, and it's really essentially the same. If you are, and these are your I'm reading from the advice of rights plea information. Number 1, if you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make arrangements. 2, you have been brought to court on a misdemeanor charge. You have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. If you plead no contest with the permission of the court, to have a trial by jury, to have the assistance of an attorney. You understand that so far, sir?
Yes.
All right, you have the right to an attorney appointed at public expense if you are indigent, without money to hire an attorney, and if the offense charge requires a minimum jail sentence, or the court determines that it might sentence you to jail, the appointing authority will decide if you are indigent and appoint counsel if you are eligible. Do you understand that?
Yes.
Which wouldn't apply here because you got a retained lawyer. You may have to repay the expense of an appointed attorney. You may contest your ability to pay the ordered fees in the court if the court attempts to collect any cost for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses. We already went over those. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind and will give up the rights listed in items 3 through 5. If you have the right to be released, you have the right to be released on bond. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jails, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. That's MCR 6.425(d)(3). And 11, an appeal to circuit court may be taken within 21 days from the date of sentence, or as permitted pursuant to MCR 6.625(b). If the sentence indicates incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days after sentencing. You understand that, sir?
Yes, I do.
Number 12, the federal law or state law may prohibit you from possessing or purchasing ammunition or a firearm, including a rifle, pistol, or revolver, if you are convicted of a misdemeanor crime or violence and you are a current or former spouse, parent, you are a current or former spouse, parent, or guardian of the victim. You share a child in common with the victim. You are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. All right, do you agree to all those terms, sir?
Yes.
All right, if there's nothing further, I'm going to sentence you, I'm going to find you, okay, let's draw your attention back to July the 19th, 2018 at around 1:23 p.m. in the city of Detroit in the area of Nichols and Marlowe, sir. And did you have an occasion on that day to be pulled over by a Detroit police officer?
Yes.
Were you operating a 2000 Buick at that time?
Yes.
Was there something wrong with the insurance? Did that officer ask you to produce valid insurance?
If I recall, I think yes. Yes, he did ask me for proof of
And
insurance.
you couldn't do so, could you, sir?
No.
All right, sir, I'm gonna find you guilty of the amended count of improper plates. I'm gonna fine you $265 for that, sir. And I told your client, your client, I would dismiss immediately upon payment of that $265. I do have that your client has paid that $265. And with that being said, I'm gonna dismiss the case and close it out, sir.
Thank you.
All right, thank you so much, Judge.
All right, good luck to you.
Can I ask one question, if you don't mind?
I don't mind, that's up to your lawyer.
Mind if I ask
I did all that work and you about to mess it up? Go ahead.
I was about to say, don't say not that. You don't have any questions.
No, look, I just want to know will anything be in writing because the lady at the lift office told me once I
No,
take care of everything.
that's not a question for you, for the judge. The
Well,
court
you
has,
can get it on the, it'll be on the register of action that the case is dismissed. I can answer it. It'll be on the register of action. Your attorney knows how to get that register of action. Give my clerk a minute to get back. She had to go to break. You closed the place down, sir. So everybody's, just give it this afternoon. It'll be abstracted on there. You'll get that on a register of action, and then you'll be able to hopefully get that job.
All right.
Perfect.
All right.
All right. Thank you.
I wish counsel